and possible action legislation.
Well, we'll do a tag team. Should we start on the, actually Terry can kind of go over the bill list. And then the 798 is the sunset bill that is huge, and we'd like to discuss that today, so.
So did everybody see in their packet this bill list? It's a one pager. Okay. It's a good side. This was divided up into the first section, bills to consider taking a position, or doesn't have to take a position, but these would be ones that probably have the most impact on the board. And then the informational bills may be of interest to the board, maybe not as much impact. So the 798 is the sunrise bill. That has the most impact, probably most detailed discussion. Angie, do you want to start with 798 in order, or the little ones?
I can certainly start on the 798. So the 798, there's three issues that we'd like to bring to your attention. The first one is, should the board adopt the Medical Board of California's provisions in the SB 798 that creates a training license and a required minimum of 3 years of residency to be eligible for a licensure, or to opt out of this proposal? Number two, if the board agrees to adopt the proposal, does the board support requesting a statutory increase in fee ceiling? Number three, does the board support the provision to require all DOs to disclose to their patients that they are on probation? Okay, so background, OMBC requested statutory changes related to the continuing medical education cycle from 3 years to 2 years, which has been included in the SB 798. Also included in the bill was to request an amendment to these Business Profession Code Section 144B to allow the board to obtain enforcement records. So both of these changes were actually requested by us to be included in the sunset bill. So when we sent them a support letter for this bill, these things were not yet included in, well, we thought the only things that we were supporting were the two things that we requested, and the fact that they would extend the OMBC for another 4 years. After we saw the bill go into print, which was after the date that we were asked to submit our support letters, we find out that Medical Board had requested several items to be included in this sunset bill as well. And so we were kind of blindsided by this, so we thought we needed to speak about these today to see how you want to move forward with this bill. So the two things that we requested, we're very pleased that the author had included in the sunset bill, and I'm sure that you both agree on that because this is something that we had talked about before. The one was the CME cycle, and the other one was that we were excluded from the list of all DCA boards and bureaus that were authorized to, well, that were required to submit fingerprints, and with that, we were allowed to purchase enforcement records and court records. And because our name somehow got excluded from that list, we did not have the authority to purchase enforcement records. So all we did was to ask the author to include us with the DCA boards and bureaus that had that authority, and they agreed to do that for us. So the medical board actually asked to change the requirement of 1 year postgraduate training to a 3-year postgraduate training requirement for licensure. So let me read that. So some of these changes were requested by the medical board and some were not requested, which included by the author and the chair of the B&P committee. One of the changes requested by the medical board is related to licensure requirement in the postgraduate training residency training. The first change is to create a training license that all postgraduates would need to have in order to continue their residency in California. Postgraduates would be required to obtain a training license within 180 days of enrollment in their first year postgraduate training. They would no longer be eligible for a licensure in their second year. Instead, they would be required to have a training license and complete 3 years of residency before they would be eligible for a full license. The MBC also repealed many of the licensure sections that the board's regulation cites in authority. In any case, the board will have to amend our regulations accordingly. In addition to creating a training license and changing the licensure requirement for postgraduate training, The curriculum requirements and foreign school approvals are being repealed. While the foreign school approval sections do not impact the board, most of the other changes to the Medical Practice Act do automatically apply to the board. These sweeping changes were intended to apply only to the medical board. So as a result, the board was not expecting these sweeping changes to be in these changes to come through. So however, the policy being these changes is good and worth the board's considering even on a short notice. The summary, the BMP section 2064.5 creates a training license for postgraduate training and residency training. BPC section 2096 changes licensure requirement that include completing a 3-year postgraduate training residency instead of 1 year. BPC section 2065 makes changes to allow for the completion of the Complex 3 to be completed during their training license period. The training license for postgraduates would replace a full licensure that they now receive during their 2nd or 3rd year of postgraduate training. All postgraduates doing their residency in California would be required to obtain a training license and not be eligible for a full license until they complete the 3 years of residency. There is a requirement that 24 months of this residency must be in the same program. These changes to licensure will also impact postgraduates with residencies outside the state because they will now have to complete 3 years of residency to be eligible to apply for a license in California. While no effective date was placed in this bill, these changes are being proposed to take effect January 1st of 2020. In surveying the Federation of State Medical Boards to see how many years of postgraduate training other states are requiring for licensure, we found that 17 states require a minimum of 2 years, 3 states require 3 years, and the rest of the states require only 1 year of residency for licensure. So the majority are still only requiring 1 year. The fiscal impact, if the board approves these proposed changes, it will result in an increase of workload requiring additional staffing. The board cannot absorb this increase in workload, nor can the budget absorb increasing staff without an increase in the license fee. As a result, in addition to considering the policy change, the board should consider requesting an increase in the statutory cap of 400 annually, 800 biannually. No, I'm sorry, to 400 annually, 800 biannually, in order to fund this in future. So we're not asking for an increase at this point, but if we put if in statute saying that we may raise it, then at some time down the line, we would be able to increase our fee by writing regulation. But right now, as it is, our statute says it's $400 2 years, so there's no increasing the fee unless we have a statutory change. So, and now would be a good time to put that in there, even though we may not be requiring or requesting a fee increase at this time. But historically, the board has not increased the fee since 1995 to 2000, when they were given an authority for a temporary fee increase for the duration of 4 years, from $200 per year to $300 a year. In 1996, the board changed their licensing fee from an annual renewal to a biennial renewal. Other than this temporary fee increase, the board has not increased its licensure fee since 1995. In comparison to other healing arts boards, OMBC's licensure fee is significantly lower. MBC licensure is approximately $800 for 2 years. Naturopathic committee charges $800 for 2 years, and podiatric medicine is $900 for a 2-year license. The board is outgrowing its current licensure fee levels and will in the future need to increase it. Increased workload. The board would essentially have to create a new licensure, which would be needed to be created in breeze and in regulation. At the very least, there would be a new licensure application for training license. There will be a significant increase in licensing and enforcement workload as a result of this new licensure. As a small board, the board cannot absorb significant increases in workload. Additionally, as fast as the growing medical profession, DO is the fastest growing profession in the United States, the increase is going to continue. Increase in licensure application is also driving an increase in enforcement caseloads. Currently, the workload exceeds current staffing levels. This new training license would increase the board's enforcement authority over postgraduate training, postgraduate trainers, in their residency. In other words, they will now be in our jurisdiction, so if something happens, we would have jurisdiction over the 1st and 2nd year postgraduate, graduates, trainings. So that would increase our enforcement workload to some extent. And the statutory changes needed, the board must decide whether to opt in or out of this new licensure proposal. Either decision will require statutory changes. If the board opts out, the board will want to give us the authority to negotiate necessary changes to ensure that the changes do not impact OMBC. This will require a combination of exception language and creating a licensure section in the Osteopathic Medical Act that would function to set out and creating a licensure section of in the Osteopathic Act that would function, well, actually it would be in the Medical Act, but a osteopathic section. Then the OMBC will make its statutory changes to the application fee to allow add the wording training license. It will have to seek an increase in the statutory fee authority. It will have to amend BPC 2099.5 to align it with the new statutory changes. So this is the 3-year postgraduate training requirement that the medical board has asked their author to include in their sunset bill. So now it is, because it is part of the Medical Practice Act, it is also going to affect us. So our decision is, do we want to move forward with it along with the medical board, or do we opt out of it? So the pros and cons, I guess, would be kind of jumping over this report that I wrote, but let me go to the next one. The next one is the notice of patient on probation. So BPC 2028.1 was added to the Senate Bill 798 by the author to require all MDs and DOs placed on probation effective July 1st of 2018 to provide notice to their patients that they are on probation. It requires the DOs placed on probation to provide notice to their patients that they are on probation. They must give the status of their probation, the end date, practice restrictions, OMBC's phone number, the website where they can look up this information, and obtain a signed copy of the written disclosure. The only exception to this disclosure are if the patient is unconscious, emergency room visits, urgent care, or an unscheduled visit. All of this information must be available on the board's website. The board currently has a lookup and provides information about all disciplinary actions, so the big change would be the disclosure by the doctors themselves. A prior version of this bill was vetoed, and the board may have taken a position opposing it in the past. Now it is back included in the Sunrise bill. So the question is, does the board want to take a position or not? So discussion. This policy proposal, the licensure and training program proposed policy changes. This policy proposal to create a training license and require completion of a 3-year residency makes good policy sense. It raises the training standards for licensure so that full licensure is awarded upon completion of 3 years of clinical residency training. It makes sense to award full licensure after residents have completed 3 years of clinical training. Requiring completion of 3 years of clinical training will produce more experienced and skilled physicians and surgeons. This policy change represents a positive step in the continuing evolution of osteopathic and medical training. Additional considerations include that if the board adopts the changes, it will keep the standards for 2 professions the same. Having the same practice standards has been important for the osteopathic medical profession's credibility and has led to the integration of DOs working alongside MDs throughout the healthcare system. This credibility issue is an important consideration. It makes sense to keep the standards the same between DOs and MDs. If the board opts out of licensure changes, it would essentially create separate licensure requirements and standards for DOs compared to MDs. The DOs have a lower standard than MDs for licensure. That may create a negative perception of the osteopathic medical profession in California. Although it appears that this policy raises licensure requirements from 1 year to 3 years, a typical residency lasts a minimum of 3 years, so that will not in reality be an increase of training requirement for postgraduates. Since the vast majority of the DOs complete a 3-year or more residency training, it will not require them to do more training than they already do now. The change for postgraduates will be to apply within 180 days of the graduation. Actually, it's 180 days from the beginning of their training license to allow them to practice in the training program, and then wait for 3 years in the residency to complete to apply for a full licensure. Overall, the changes would be aligned. The licensure Overall, the changes would better align the licensure with the minimum clinical residency training that already exists. This may create a positive perception among the public that the board is increasing its public safety protection. This change may impact some of the state's applicants who apply for licensure in California who have not completed 3 years of residency. Although most states do not require 3 years of residency for licensure, most postgraduate training graduates do complete 3 years of residency. So this change will not be an obstacle for them in applying for California license. This change would increase workload for the board to implement and require future fee increase and increased staffing to implement. However, current workload is already exceeding staff levels, so this will not be the only driver for the increasing of staff and the need to increase fees. The implementation workload in the overall scheme of things is a consideration, not an obstacle. There would need to be statutory changes in this bill either way. There would also need to be regulatory changes either way. For example, the board would have to amend section 2099.5 to align with the new changes, since many of the sections relied upon are being repealed. 2096 may need to add American Osteopathic Association. The board is outgrowing its budget and will need a fee increase in the future. SB 798 would be an opportunity to secure that authority to increase the fee in this future. The board's fee increase history has shown that it has not increased the fee since 1995. The board is experiencing the trend that osteopathic medical profession is the fastest growing profession, and that the trend is expected to continue. So the board needs to consider the proposal of the increase in the statutory authority in SB 798 to facilitate a future fee increase. An increase in the statutory maximum of $800 for a 2-year renewal would meet the board's future fiscal needs. Notice to patients on probation. This is a significant policy that impacts DOs, and the board needs to consider the policy and see whether it supports or opposes it, or has a compromise proposal with respect to this policy proposal. This would impact DOs who are on probation, but may have very little impact on those not on probation. Supporters of this policy proposal believe it will better protect patients, and that the patients have the right to know that their doctor is on probation. If they knew about the probation, the information may affect the choice of physician for patient care. Patients already have access to accusations, disciplinary orders, including probationary terms and conditions. If the patients want to find out whether their doctors are on probation and the terms of their probation, they can already access this information on the OMBC or the medical board's website. The compromise proposal could be to support this probation notification for cases which involve such sexual misconduct, criminal convictions related to the practice of medicine, or drug and alcohol intoxication during practice, or other violations that the board may feel appropriate.
So I'd like to have Dr. Valley put his hat on, because he's part of a training program, and he's been involved in national education for years.
Yeah, so right now, the law states that at the end of your second year of training, you have to be licensed and you cannot enter your third year. And that's worked very well for the years. So there's a kind of a double impact thing going on. One is the burden it's going to place on the board itself, because the money's not going to be coming at the same time that they propose the change. We have to do bureaucratic changes and administrative changes. But the other part is these kids, calling them kids, these residents are in a huge financial dilemma as it is. And I'm not saying good or bad with it, but allowing them to have a license after their second year of training does allow them, as long as they're following the rules of the residency, to pick up some opportunities to moonlight, which nothing is better than the experience of actually doing something as far as strengthening their ability to work. The next thing is even though our board only takes 52 days to get someone a license, that's our current, right, 52 days, the influx of the number of requirements for that can probably take it out 60 to 80 days, which then means he's graduated and unemployable, because you can't hire someone unless they have a license. So no one's going to go out on a limb and say, oh, well, I'll take you, Dr. Zimbo, you seem like a good guy. We don't know, but you're useless to them until you get the license. So I think that with the shortage of physicians we have coming up, with the fact that I think delaying it a year, I mean, most of the residents choose whether they want to moonlight or not. It's not mandated on them. So some wait till, they get almost done, and they scramble around to try to get all done before they get hired. But I think to mandate those things, it's just gonna hurt us a little bit. So let's go back to the next thing. They're not as well trained as whatever. I think that was a comment that we have different licensure. That, well, that's all going to the sidelines because the ACGME and the AOA have entered into a single accreditation agreement that everyone's going to be trained on the same standard. So I don't know where that's an argument anymore because the background and training will be the same. So I'm worried about the financial impact, already overworked group. I'm also worried about the impact it's going to have on our society come that period of time where suddenly there's a big influx and they can't work. I mean, they're literally going to graduate people that can't work. That's my 2 cents on that. So, ma'am?
Yes, I did review this before I came here, but now that I see that there are other concerns other than the ones that I caught, to address your concern about them not being employable, I just wanted to point out that the training license is valid for 90 days after their post-grad training. So I don't know how long it takes
Okay,
to.
now you know.
Yes.
Oh, no, I don't.
didn't read that.
I don't know
Okay.
how long it
Sorry.
takes to get a license, or how long it takes to take the, what it takes to actually get a license and how long the process takes. I don't know if that 90 days is sufficient.
52 right now, but
52.
but
Okay.
that's
Well,
all
anyway,
they do
I'm
in the
just.
toilet when there's
Okay.
800 more you have to do within
Oh,
July.
absolutely.
of the
So
year
I'm
to
just-
graduate.
I'm just letting you know, I'm not pro or con or anything. I'm
understand.
just.
I didn't know
yeah,
that.
just.
How long
just
is the
letting you
training
know.
license
Training
last?
license good for
90 days after the 3-year post-grad training is
Okay.
over.
But Eliana, can
But it's
you
restricted.
read that again? Because to
Yeah.
me, the way I read it, the 90 days, the holder has completed after the holder has completed 36 months of postgraduate training,
Right.
the physician and surgeon's postgraduate training license may engage in the practice of medicine only in connection with his or her duty as an intern.
Right.
So they have to
Agreed.
be in a training program.
It does, yeah, exactly. It doesn't address down moonlighting anywhere.
Well, once
Right,
you're
so
done-
what I'm saying is that after the 36 months.
Once you graduated the training program,
Mhm.
Right.
now your training license is no longer valid.
Because you're not in a training
Right.
program. So even though you've got that 90 days to get it, you still can't do
Useless by the
anything
language
until.
of the law.
Right,
No, no,
that's how I
That's great to
interpreted
point
the
out,
law.
so that maybe the legislature wasn't aware of that when they were drafting this.
Dr. Kerman?
I had a question regarding the third year and the full licensure. Is there not something that's coming by the way that says they cannot use that license to moonlight? They can only use it in the pursuit of the completion of residency?
That's what this license says.
Yes.
sir.
Yes.
This proposed change
Proposed
states
training
what your
license.
state.
So Dr. Bahari made a very good point that if you're not in the program anymore, what are you going to do for 90 days with a license that you can't use? If you could only use it in the program.
So it is somewhat kind of like a restricted license in the sense that it's restricted to only practice in a
They
residence.
can't moonlight.
Not moonlight, which would have a
Right.
full licensure, which they have now. That was the change.
They're wanting to change it to say that you cannot moonlight.
Well, you won't have a license for the 3 years that you're in the residency.
So you can't.
Now,
So
currently,
the
you
short
can
answer is
get a
yes.
You have
license.
to have it in the third year.
That's the effective outcome,
No,
yes.
Yeah.
well, currently,
There-
yes, you have to have a license before your 3rd year.
Yeah.
So in the 3rd year of residency, you may moonlight because you already have a valid license.
But see, in Fresno, we had a resident ER who was kicked out of the program after his first year, and he went and worked at a
Urgent
clinic,
care.
in an urgent care somewhere, and was making a good living, never went back to residency because he had a license.
Right.
I think that is maybe what they're trying to address here.
Yes.
Yes,
Yeah.
yes. They're trying to, so the trade-off is what you're saying, practically speaking, whether people are employable on a full license versus it increases the board's jurisdiction into that situation so that the training license would now increase the board's jurisdiction to the first year of the training program, which it is not currently until they apply for full licensure. The full licensure application and granting is the first time the board has jurisdiction, enforcement license.
Correct, because right now, if I have a resident that writes scripts and has that, we have no jurisdiction over it because they're not licensed. And we have no recourse to where to send them other than you throw them out and you call the police.
So my understanding of medical board's discussion, from the medical board staff, they've been talking about this for a number of years. So, the being caught sort of in short notice, I do kind of feel for the decision making that feels rushed, because they had like 4 years to talk about this. But I think that the intent was that they had been thinking that this was a better way to manage postgraduates in terms of jurisdiction. And they wanted to have that ability to find people, like you said, that were kicked out of residency that are still out in the system, and, may harm patients until they come up for, an enforcement case, that this would be an early warning system for protecting consumers. So, and it does come with the trade-offs of what you're highlighting, exactly.
I mean, I don't want to go into adopt a process that makes things more cumbersome.
Well, I don't know what the financial impact is on a group. I mean, I would want a fiscal representation of how much this is actually going to hurt us as a licensing body and providing over. I mean, they're already overworked and understaffed.
Right.
Well-
And that's not even being politically correct.
No,
right.
That's just a
I
fact.
agree.
Yeah, so earlier in the board meeting, we did indicate that we have submitted 2 budget change proposals. And it's not just because of this, we are actually really, our workload in our office has got to the point where if we had one more anything like this put on our plate, we're overflowing. And that's the reason why we're requesting staff and additional budget. Whether this goes through or not, we're still gonna need that.
Sure.
that
What's our
budget.
timeline in terms of making a decision to be for or against the concept?
Well, the timeline for this, because it's attached to a current bill, which is our summarized bill, and it will automatically affect us if it's signed into law, which is likely to be and effective, then we have to put in language either way, opt-in or out, by, I would say, well, this board meeting is in May, so we would have to undergo negotiations with the author, probably in May, June, and get something in at the very latest by July, because they go into the final bill stage, and concurrence and stuff, so they're not gonna be adding things in August.
So with the obvious elephant in the room, if we don't go along with this, is this going to impact how the legislature feels toward us as a sunset? And they give that one more reason to do away with us? I'm just asking.
I don't think so. I think that the legislature it wouldn't, quite frankly, apply to us, so they wouldn't. I think they're caught by surprise. We haven't had additional contact with them once we saw this language, because we thought we can't move without knowing where the board's going on this, yes or no. And so I think that they, given the fact they didn't realize it accommodated us, I think that they're willing to hopefully do whatever we need, whether it's opt out or opt in, for that. And so I don't think that we would, I don't think that they would look down on the profession or the board for that.
I was going to ask, are there any public comments regarding this specific?
On this specific issue, no.
Well, just about the bill in general.
On the bill in general, absolutely.
Can
Do
I
you
s-
want me to talk about that in general? or
Can you
just
say
this
who you
specific?
are and where you're from?
Absolutely. Kathleen Friesen, Executive Director of the Osteopathic Physicians and Surgeons of California Association, representing osteopathic physicians. We currently have a support if amended position on this bill. Support because we like the fact that it would extend the licensing, the authority of the Osteopathic Licensing Board. Also are supportive of the modifications to the continuing medical education aspects as far as the timing of submission. Have some pretty significant concerns about notification regarding the physicians on probationary status, mostly because the administrative burden that it would place on those physician offices. We have remained neutral on, with respect to the requirement for a 3-year residency.
Can I add something? Not to your comment, although very good comment. Was that whatever comments that the board has about the bill, you can always put it in a letter, support if amended, and explain what the concerns are and ask if the legislature makes these changes. And, I think what Terry said is very true. I don't think that the board would necessarily be looked down upon by putting out the feelers on, hey, we're okay, but can you do this? That would be really nice. And I think that would be a really good way to address these things.
So, strategy-wise, behind this is strategy. It's not like an overarching policy reason, but The advantage of utilizing a sunrise bill is it's easier lobbying wise and workload wise to get things done. Okay, so if the board was inclined to jump into this policy and embrace it, it would be fast, it would be relatively little lobbying work. The board feels rushed, not sure they want to do it, maybe want to consider it next year. If there's an opportunity to do it, we would opt out, so the bill wouldn't go into effect, because they're likely not to put this section into effect until 2020. Several sections of the bill have different implementation dates. They haven't put this one, the medical board saying to us, January 1, 2020. So we would have time to do it. The other strategy-wise is that if our BCP, for example, doesn't get approved, which a lot of them don't, legislative BCPs often get better approval, have a better chance to approve it. That's not a good, it shouldn't be the only reason to support a policy if you have concerns about the policy. So, but timeline-wise, we do have to do the opt-in or out decision. And then the opt-in, we could ask for the second fee increase. I guess we could ask for the fee increase even if we opt out, but it wouldn't be related to the legislation.
What do we pay right now?
$400 a year.
And we want to pay $800 every 2 years?
Well, we can go the ceiling. We're wanting to request the ceiling of 800, which means by regs, we can say an increase of $100 a year
Until we reach it.
until we reach 800. Yeah.
Not a year, I'm sorry, a year?
No, 800 every 2 years. So we,
So
yeah,
we're going to double that.
we're going to double it, right? But keep in mind that back in 1995, they actually increased your license fee to $300 every year.
It was 300.
Yes, and then, but only because they wanted to bring our funds back into a healthy state, and then, so they gave us that for 4 years, and then we had to reduce it back down to 200, and it has never gone up since.
So that's also after they took the money that we raised in that and they used it for something
Right,
else.
right, still have 1.5.
Just saying.
Right, exactly.
That is
And
correct.
the other thing is that the difference between setting it in statute, statute ultimately gives the board authority to charge a fee, and it becomes our ceiling, and then we can either get fees from our regulations. So just if we put a $800 cap, for example, it doesn't mean we'd automatically go to it. A decision would have to come from this board. How much, based on fiscal? So you get another decision shot at, the 800. Do we go on gradually,
May I ask, Ms. Creason, is OPSC in favor of raising fees?
We actually haven't discussed that consideration at all.
Okay.
Any other comments?
Are we commenting also on the probation aspect now?
Not yet. Let's do this one.
Just,
This is just on the education.
Yeah,
ACG.
I also wanted to talk about the fee, that every year, we are actually spending more than we're bringing in. So if we continue to do this, and if we don't get a fee increase, eventually we will run out of money.
and we're thinking it could be around 2020, 2021. So
Right.
a lot of things seem to intersect that might be separate. But fee increase wise, this is an opportunity to raise something that wouldn't go into effect till 2020. So this fee increase wouldn't go into effect till 2020. We're not going to get the authority right away.
No,
So Angie, just to clarify your position, you think we should go with this?
the fee increase or the postgraduate training?
Which? Either me.
My personal opinion is to go yes on both, but the decision is yours.
We tried to write this so that you could see everything that you need to consider, because it really is the board's decision.
But we can piecemeal this.
We can. We can say that we support this bill with the exception of, with an amendment of this, this, and this, so.
I think that it is a good move to try and protect, because I've seen the same thing that Cider says, where someone practices after 1 year and is either kicked out or not continued in a program, and then they go out and they practice because they have an active license, and that I do not think is in the best interest of the public. Having said that, it seems very restrictive. That will be a few cases. It seems very restrictive to then have every trainee coming out of the program have to wait 52 days or more in the summer before before they could actually get a job where they could practice, because that license as well is related to whether they can bill through insurance, whether they can, so, which usually takes another 4 to 6 months, depending on the insurance company. And so I think that that's really restricting on every single graduate. I think the first part's a really good intention, but I'm not sure how to make it better for that.
Angie, if you get more stuff, can't we reduce the 52-day number? I mean, that's just what we're currently running at because of shortage of staff, right?
Right, I mean, by 2020, I'm sure that we're gonna have more license applications coming in. It's gonna be a
So you don't think
workload.
you're gonna be able to grant licenses in less than 52 days?
Well, if this budget change proposal that we're requesting additional staffing goes through, it'll go through before 2020, and I think we'll be in good shape. But if the budget change proposal is denied, which a lot of them do get denied, it may be a burden on the board.
Then we'd be in bad shape
Yes.
going into this.
But we can-
Kathleen?
If I could ask a process question, an individual can apply for a full license before they have achieved
That's
that.
what'll happen, is they'll take all their steps, with about 6 months to go in their 3 years of residency, so they're all prepared, and then you get a massive influx of applications in March.
For license.
Right, but part of license, you have to have completion of.
Yeah,
You have to have the certificate that
that's
says
the
that you
thing.
finished. That's one of the steps.
yeah, that's the thing.
Right.
And then you brought up a good point, Elizabeth, and that is after you get your license, you get your DEA, another 6 weeks. And then after that, you have to get your insurance and your privileges. So you're really probably looking at 9 months, after you get done.
And that's every single graduate.
Yeah,
So
if
if there
being
were some way
unemployed.
to write it, I don't know, to try and
And if
decrease
the
that
training,
time
if the
frame
training
to
license extended beyond their training term for, let's say, 180 days or something, give people time to, or 200 days, that would probably be reasonable.
But are you worried about the processing gap or what the scope of their license gap is?
Well, you can't apply for a license, according to this, you can't apply for a full license until you've completed
Right.
the 3 years of
Right.
residency,
Okay.
or residency.
Uh-huh.
You can't apply. So we were saying, okay, could you apply in March, and then by the time you're done, there's your license, that won't work
Right,
with this
okay,
language.
okay.
So
Yes,
the
okay.
original application for your postgraduate training license, according to this bill, would require the fingerprint processing, the complex levels 1 and 2 to be submitted, and background check, or the fingerprint check, so forth, and completion of a application form. So when they finish the 36 months, all we're looking for at that point would be the complex 3 that they finish and the successful completion of the 36 months. So by rights, it's not going to take that long to get their license because all their application process is done prior to them going into the postgraduate training.
And you can use that.
Yes.
Yes. So it would be a string more, so we were envisioning when we were trying to think about daily operations, it still would be an application process, which considers review, but lesser documents. And one of the delaying types of documents is fingerprints. That would be done through the training license itself.
Well, you bring up a good point. I accept Zumuto into my training program, and he only has 180 days to get licensed, and he has a fingerprint issue. Do I toss it? I mean, y'all are saying by law I have to toss it.
Right.
So with foreign graduates, with people going to different places, being born in different places, I don't know how long it takes for an Italian to get a fingerprint. I mean, and I'm picking on that. But with the diversity we have in graduates and the people we have applying to programs now, I can't guarantee that they can't get it. They can't get it in 180 days.
Well, Angie, one of your concerns was whether there could be language created if it was an exception to 180 days, it was the board's fault.
Well, that'll be good to have.
I mean, that's like a rough version of the gist of
Can I ask the question, is how broke is the system right now?
in terms of the application
Is the
process.
system broken?
It's not broke.
Well, my point is, if it ain't broke,
Then why
why do you wanna fix
fix
it?
it?
Yeah, the question is,
That's-
what is the percentage of dogs
Yeah.
graduating after less than 3 years practicing
Are we
medicine?
gonna wag the
Little.
tail for the dog?
Very few.
And is there another way? to
Because
do it?
you gotta remember, they can't get on any insurance plans, they can't unless they have board eligibility and
Yeah.
board certification. So they can work at urgent care, you know, they can work for like this volunteer thing. Eventually, you're gonna run out.
Well, that's a good question. Ileana, what do you think? When she's asking, would there be another way to get jurisdiction over the postgraduates? Because halfway in between the 3 years, they gain licensure, so that's when the board's jurisdiction attaches. Is, what kind of language, if there is, could increase that board's jurisdiction over a basically an unlicensed individual?
Well, practice is not a license.
Yeah.
I mean, that, anybody's under the board's jurisdiction if they're practicing.
No, but they're gonna get a license, they meet the criteria for a license. If they
Right.
finish
Yeah.
1 year and then they,
Yeah, so there is, other than the unlicensed practice, there wouldn't be, like, if somebody, let's say somebody did patient harm in the first year of their residency,
Right.
and the board would want to bring an enforcement action, right now they can, because they're unlicensed, they can bring it under unlicensed practice.
Oh, in the first year?
Yeah, that's what she's asking for.
You
Is it
know, I have to look
conceptually
at the Practice
possible?
Act to see what, because under here, it does say that, that the board can bring disciplinary action against the license of the trainer, or of the trainee.
Right, that's one of the
Would
new-
it, honestly, I'd have to look at the Board's
Yeah,
Practice
yeah.
Act to see
Yeah.
what it says, because you haven't been my client.
Yeah, no, that's fair, I just thought.
Yeah, so I would need to check, but I'm happy to look
Yeah,
into it.
yeah. I think, just off the top of my head, the jurisdiction attaches with the licensure.
Yeah.
And that's where we define whether we have enforcement authority. So short of that, I don't know what language we could say, because it would be really arbitrary to say, wow, now these deals over here, suddenly we can prosecute for any reason other than unlicensed activity. The full range is if we would have, licensure. So I'm guessing the answer is no, there is another way to get a wording in that would also solve the problem. So it is a trade-off.
Well, I think the most pressing issue at this point is money. We know we need money. That's something we have to, what do we need to make that aspect of it? We support it.
If you support the increase, we can request the audit and come back into this cycle of sunrise.
Move to increase.
Does it require a vote?
Well, it makes it official.
Yeah.
It's a motion.
Is there a second?
Second.
And Howard agreed with me. Alan's agreed with me.
Oh, yeah, you're gonna vote
if
that.
proxy is.
Do we vote?
Dr. Smitha,
Yes.
Dr. Raleigh,
Yes, yes.
Dr. Murray,
Yes.
Dr. Jensen,
Yes.
Dr. Mercado.
Yes.
So we got that done.
Okay, did we specify yes 800? Will you specify a number?
Alan,
Yeah,
you gonna give us more money? We're voting on money.
we're voting on money.
Fee increase.
Fee
Oh,
increase.
yes. I vote yes.
Yes.
John?
Thank you.
And was it 800?
800.
I would have mailed that to you after.
Is it an amount that we're voting
The
on or
ce-
just
the ceiling,
the ability
ceiling,
to
ceiling,
ceiling at
800?
800? Yeah, okay.
Okay.
Thank you. So,
This is how we do it. So now it's being webcasted.
Hey,
I bosses.
That's okay.
It was official, everybody.
You did ask. You did ask.
okay,
We're good.
what's next?
Okay, so we're doing the no, do we vote, we didn't vote on the training one.
Motion to leave, motion not to opt in on part one.
Is there a second?
I'll second that.
What is part?
Post-graduate training.
Thank you.
Sorry.
Okay.
All right. Say the vote.
This is to
So
not.
by answering
to not-
yes, you're saying not to opt
To
in.
not attach the OMBC to that provision.
Thank you.
So I would say for clarification, the changes in licensure and training program, because it gives us the authority to make all the opt-out in all the different sections.
Except that,
I accept that as a friendly amendment.
Okay.
Dr. Smitha,
yes.
Dr. Raleigh,
Yes.
Dr. Murray,
Yes.
here, Dr. Jensen,
Yes.
Dr. Mercado.
Yes.
Okay. No.
And then the third part is the probationary.
Yeah.
Sorry.
Kathleen, would you just, again, I'm sorry, you felt that us having this required, that they have to let people know that they're on probation, is this put a burden on them?
Yes, because as the language is written, the physician or physician staff would have to have every single patient document attesting that they have read and understood that the position is on probation. And that's going to be very, very time consuming. It's going to require a lot of conversation with the patient that will take away from the opportunity to provide patient care.
So, I must not have read that, where they actually, I just had here that the doctor needs to post in his office or make known to his patients that he is on probation. I don't.
Status
That
ending of probation.
But
Requires the
it'd have to be
licensee to
something in
provide.
writing, other than posting what they currently have to do. They would have to have probably a piece of paper designed to meet the statute that gives.
Prior to the first visit with that.
Yes,
individual.
right, yes.
Prior to the first visit only.
So it's,
I don't mean to be mean or sound, but you know, they did something wrong. I don't, why not just not do anything wrong and then you don't incur any expense?
Secret is to stay off probation.
Yes, so the plan is to do what you're supposed to do and stay on probation. So you go on probation, what's the length of probation? 2 years? I guess that
could be
depends.
five.
It could be a
5 years.
Could be 10 years.
Ouch.
Yeah,
Well, still,
the suggestion that we could also modify this, and that would be a consideration I think we should
Yeah.
have. Is it for felony charges, for criminal?
but I don't know if we should
convictions?
start picking the
Yeah,
list of what
that's-
you should be
Right.
reporting, because then someone will be offended that you didn't think that mine was worthy
You
to
were
have to
offensive.
tell you to be. What if we did this? What if we offered that the doctor needs to let it be known that he's on probation, and they can do that in some sort of public, or some sort of printed format? So they can put a little card by their desk, a little plaque on the wall like we have now.
they
that
have to have
says-
it written, have the patient
It
sign
requires
it
a
and put it
No, no.
in
No,
the
but
medical.
this
Wait.
is modification.
Oh,
I'm modifying, I'm asking for a
Okay.
modification. So right now, we have to have posted in our office, if you have a complaint about me, you call this number. Right, we're supposed to put that everywhere. Okay, so why could you not have a placard underneath there that says, this physician or Lally Dio is on probation for this period of time due to this, and it's there, and it gives you a chance to call, to verify it if you want, or to go to a website, they're duly notified.
Further information is
Yeah.
available on the website.
Right.
The information's already posted.
It's going to impact your business.
Well, it is. I mean, it most surely is, but it's also going to impact your business that you did something stupid.
It's true.
Sorry. So I mean,
Right.
again, we go back to this thing about we do something bad and then we don't want to pay the price, and we start negotiating right away that we did something wrong. Well, then don't do anything wrong. Sorry. I mean, people like, there are doctors that practice 48, 50 years that have never been on probation, that have never had an issue in front of the medical board. So why don't we use that as the role model instead of people negotiating that, well, I don't want to tell everybody I stepped on my feet, let's just let it go.
There's not that many on probation to begin with.
Oh, okay.
It's not that big.
I want to hear what Ms. Mercado has to say, because she is generally
Yeah,
she's generally a huge proponent of,
Yeah, of patient
the
safety.
patient safety and public interest.
Oh.
I think you always have that aspect, and I want to see what you think.
From what, when we testified at the sunset hearing, and we saw the medical board, present, and there was an array of people there to testify against malpractice and an array of issues, I think this is a problem that addresses some of the concerns happening with the medical board and some of the MDs, in the malpractice that occurs, how it's not really caught immediately. I don't think we have that problem. I think we're pretty effective board, not to say that they're not.
You can say that.
You feel we're
I
more.
am so sorry to interrupt you in your thing, but we only have 4 board members here right now, right? So we don't have a quorum. I know we.
But we're not voting on it.
I know, but
Well, we
Was
could
he-
kind of have to
because
vote
of
if we
worthy
wanted to have
order.
an opinion. We don't have an opinion.
Well,
then we
Dr.
vote.
Zamudo makes 5, he's just away
Oh,
no,
okay.
I know he didn't go anywhere. He just
She means
stepped
for
off for
our
a second, but
Over
yeah,
the
but
discussion part.
yeah,
Okay.
yeah, that's all I'm saying. Is technically we're not a meeting.
Okay.
Right.
So can we take a quick pause? I'm
Sure.
Sorry, I
Pause.
have to do this to you guys. I
I'm gonna
know.
get some pastries and
I would just recommend the eclairs.
They're both delicious.
Do you own that bakery?
You know what, I- getting ready to wrap this whole thing up for us. A very, very nice man.
He is-
all right,
he's gonna
so-
Buy someplace.
I did read somewhere that the average consultation is about 15 minutes versus an hour in here. I think that's correct. But that gets me thinking about how much time is this going to take away from the consultation. If the patient is so intrigued about the details of the case, there's a lot of unknowns, they get into tuition for 5-10 minutes, then what's left for the patient? We're talking about signage and
Yes.
reporting. So that's my
Disclaimers.
disclaimers. So I think getting too deep into the details, I think is not beneficial. for the
I would suggest to you that very few patients would actually sign that, they would walk out.
Especially if you've never
really?
met.
To ask them to sign
This is
something?
your,
I agree
this
with
is
you.
your first visit with the new
Right.
doctor.
Yeah,
Now you're signing something that's saying, by the way, I'm on probation from the Medical Board, Osteopathic Medical Board of California. I'm informing you. You can get details on what happened on the website, etc. These people are going to leave.
Well, I mean, it's hard enough to get them to do arbitration agreements, and that's for their advantage. So I can't even imagine setting up a little mini
Right, so-
bio about what you did 2 years ago.
So what I was saying is, I mean, we have grades of what we can do to a license, to censure the license. You can put probation, suspension, revocation. This takes probation to a much more punitive level is the problem. I mean, it'd be very difficult for a physician on probation to earn a living. I'm not saying that they shouldn't do what they did to get on
which
probation.
is why actually talking about whether it should be all and broad in its application. Angie was giving the
I'll give you an
example.
example of a doctor who's on probation because he had 3 DUIs over a 10-year period. But he's never been intoxicated at work. There's been never a patient complaint against him. The only problem was that he had 3 DUIs, which is criminal offense. We had no choice but to place him on probation, put him in the diversion program. Somebody like him, I don't know why he would have to tell his patients, oh, by the way, I'm on probation because I had 3 DUIs. It's not going to affect his practice at all. He's never had any intoxication at work. He never had any patient complaints or negligence or incompetence. I don't think that he or this type of probation should be included in this. However, if the patient was on probation for sexual misconduct or something like that, I think that the patient should have the right to know.
What about what if
That
we
doctor
what if
should have a
we
license.
Yeah,
The
Negligence.
Osteopathic Medical Board, I don't think has anybody on probation right now that is has a violation of sexual misconduct. However, we do have some patient doctors that struck up a relationship with their patient. And, yeah, so they're on probation. And it was a one patient isolated thing, but they are on probation. Somebody like that
Yes,
maybe
Bobby.
should have the right to, I mean, maybe we should have the right to tell this doctor that you need to let your patients know this.
There's a way to
That
handle
you date
that.
your patients.
well, why don't we just educate why don't we flip it around and say why not educate the whole public about what a deal is, how to contact somebody if there is a case of negligence, and get the public more aware of how to take actions versus just lighting up a red light when there's something wrong, because we might be missing all these red lights along the way.
But we do that now, right?
So can we
Yes,
buck
that
it
is
up?
required. The notice to consumer, just in general,
You have to
the
have
contact,
notice to
yes.
consumer. But
How big is it? Like, what does that look like?
it's a placard. I've seen one.
Then, I mean,
I mean, there's no requirements on what size it is. It just says it must be visible to a patient as they enter, your office area.
And we will be working with Ron Lawrence that after this board meeting, we're gonna set up some time to even make brochures so that doctors can place those in their waiting room. You know, what's a GO? If you have any concerns, if you wanna know more about my practice, you can contact the Osteopathic Medical Board. Those brochures can be available to put in the physician's waiting rooms. So I don't know if that would make any change or,
So can we, at this moment, opt out on this? Because this is also a discussion issue.
When we opt out, we have to oppose it
yeah.
to opt out. So it's not
Meaning-
exactly like the training license. The training, because the training license, they sort of thought, oh, it didn't apply to us, but it really does.
Okay.
This one, we were specifically named as a board alongside the medical board where this has to apply. And the fact that they did this and are using the full force of the committee to get this done, my guess is opt-out is a non-starter.
Okay, so then could we opt in and request a little change in wording?
Yes, that's, the medical board
Update
did.
with amendments.
Was it an amendment or
Yes.
caveat? Because here's why. If you read this thing, they're saying that, well, you don't have to tell somebody if they're unconscious. Yeah, I get that. But you don't have to tell them in the emergency room. You don't have to tell them in the urgent care or your unscheduled visit. My license didn't get on probation because I was working in an office. My license on probation because I screwed up somewhere in the continuum of care. So why is it that those areas are excluded? Should we know that?
Because of the time constraint, I'm assuming.
Time constraint of seeing the patient?
Right, because if you're in an emergency room, you have to immediately treat the patient. With this notice, you have to give the patient, have them sign a consent. You know the patient's gonna ask you questions. Well, why are you on probation again?
Can I see
You know,
another
can I,
copy?
yeah.
Well, are there ER docs on, doing ER work, full privileges on probation?
Yeah, we just had one.
Okay, so then it would be a.
Entire emergency room would be probationers.
Yeah, so the whole ER would be put through a stop.
It would.
So why couldn't we ask them to say, that it requires DOs to give notice to their patient? Here's my notice, and it just says that I'm on probation from 18 to 19, and if you want to know why, call this number. I have to say
Versus
why.
signed. The question is, how would we enforce this? Just to make sure that every
Somebody
single
complains,
patient
right?
got a signed copy of the I'm on probation letter.
Yeah, no, you're right.
I mean, that's gonna be a massive undertaking for
Well, you know,
enforcement,
it's
even
like-
for 50 or 60 probationers.
What it's like, because we don't look at the audit every single medical record for every single doctor in California, is when, like consent, when somebody gets involved in an enforcement case, one of the things you look at is do they have the paperwork and the proper paperwork? So if somebody also didn't
That's
get
true.
consent, even, that also becomes a violation and you start to, have more causes of action. So we probably wouldn't detect it until it became an enforcement complaint. It could be easily a reason why somebody could complain that works with the doctor, so we could get it there. But you're right, it would be really tough to enforce.
If the doctor has a probation monitor, that would be another thing. that
Yes,
the
then
probation
we could
monitor would have
monitor.
to look to
Yeah.
see if they have signed consent.
Because then we'd
Yeah.
expect them to have an examination of all files that were relevant in a period of time, and do they have a
So
sign?
your electronic record would have to have a built-in statement that I discussed with this patient in detail in my probation, right? Then that person would sign, they would take a copy, and they'd need to sign something to get your copy. Oh, I don't know, that's a lot of work.
But what do you say? You
But
say,
does that offer more protection to the public than what's currently being done?
No, it
No, I
offers
think it offers anything.
It offers
It
restraints
confuses-
of trade against doctors who are paid, on probation. And the problem is it's worsening the probation than it needs to be.
Well, it makes it more punitive.
The
Well,
author, yeah.
why offer probation and not just suspend the license in that setting?
Well, we should just do away with probation,
That's what's going to happen.
right? We should just do away with probation, because suspension carries less negative impact on you, you get a revocation of stay. So,
I think the author's intent was that every patient should have the right to know who they're seeing.
Joe, I have a question. Talking about probation, is it not mandatory that you report that you're on probation?
do.
Did you make it known?
No,
Not right now.
No.
This is
So
what,
why would you-
It's
why would
public
you make it known?
information on the website, but the
so
patient
this
has
is
to.
the
Right,
law
make
that's
the law.
going to make that a
If it's made
violation.
law, then you want to make law?
No, if
Somebody
they've
else
already,
make-
they've already
Somebody
pushed
else
it, it's
make
in the
that.
sun,
No one else make it.
And it applies to us, so
If
we
it
can do
becomes a
nothing.
law, you don't have any choice.
Right, right.
You're-
Then you want to decide what you expect the doctor to do with the patient. Is he going to have him sign something saying that he told him he's on probation?
that's what the law is asking for.
So
Starting July
you argue with that?
Yes.
Why?
Say it again, Dr.
It's a
Kerwin.
law, it's a law.
No, Dr. Kerwin, right now we have a chance to maybe make it have more sense and less negative impact. I don't dispute with you, it's the law, but there are some laws that don't need to really be in effect. Just
Well, it
saying.
hasn't gone into effect, so not that you have a lot of success with altering the author's opinion
Oh, you don't
about
think
it.
so?
But, well, the author is seeing this as a very good opportunity to make this go through. But in the form of public discussion and public discourse about forming a new policy, the author has to be open to the input from the relative boards. NBC has indicated that they would require a modification. They supported in general the idea, but by certain offenses.
What's theirs?
Their modification, I think Angie sent.
Oh, it's right here, I'm sorry. They're only gonna do it if you have sexual misconduct, criminal conviction. Oh, so that takes up the drunk. So that could actually, that wording could actually protect doctors that don't have probation.
Correct.
It's not directly related to. Well, he was a drunk. Sorry.
Okay, so the medical board is requesting
You get it wrong.
implications of sexual misconduct, drug or alcohol abuse during practice, criminal conviction involving practice of medicine, and, or if the licensee has previously been ordered on probation, so I guess a multiple violator.
Right.
Yeah, so,
So we did that. That would narrow, Kathleen, that would narrow the number of people that are on probation for these particular issues. So then maybe it's more palatable because it won't affect any of us that aren't on probation.
Right.
So those
From the worst
doctors
to the worst.
would get punished.
It seems, I mean, from what I've generally seen recently, public opinion is also that why are people not being informed more, that
Yeah.
people should be informed. So if we want to, as a board, reach out and say we are trying to protect the public interest and we see that need and that desire and we respect it, but we feel that the way it is written is a bit extreme, I think it would be okay to do basically almost exactly what the medical board's doing, and then both boards stand together and saying this overall bill, or this overall BBC, blah, 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 is extreme. Not every patient should sign for every probation. That's why we have probation, but for those particular circumstances, both boards agree that those are extreme.
Is that a motion?
Who's
Sure,
sponsoring this bill right
that's a
now?
motion.
NBC.
no, this bill is Senator Hill.
Oh, sorry,
Senator
Senator Hill.
NBC had a certain group, now,
Except with that.
right, so one of the things not on the list is incompetence, right? Negligence?
Say that again, I think we lost you.
One of, the NBC exempted a lot of offenses, and among the ones that they exempted would be incompetence and negligence.
Negligence was one of the biggest concerns from the public during the sunset.
Right.
And that
So-
was actually 90% of it.
So I'm just pausing for the board to consider before you launch into the laundry list and automatically accept the medical board's list. Think carefully, is that the list that you really agree with in terms of what you're trying to notify consumers to make an informed choice?
What is the most, the
Common.
highest number, yeah, the most common for us on probation?
What's the violation?
Usually a complaint is negligence.
Over prescribing?
Well, no, in terms of complaints, general
Oh,
complaints.
complaints is
Right, but-
negligence, but for the most part, after it's reviewed, we find that it was within the standard of practice.
How about for people actually on probation?
Most of
I
that,
have a motion, I need a second for
Oh,
discussion.
second. Sorry.
Any more discussion?
Yeah, I want to hear what it says.
Negligence.
Under negligence.
well, no, on discipline, if
Under
it
negligence.
goes to discipline, then it's,
Negligence.
actually, I don't really know what the predominant violation is.
Or what's the overall?
But we do have a lot of overprescribed.
Negligence,
Isn't that negligence?
candy
That's
dogs,
what that
form
was
of
when we went to
negligence.
Yes.
category.
self-medicating.
Self-medicating. People allowed to
Self drugs.
Why don't you offer a friendly amendment to the senators and would eliminate these categories of violations from notification?
Sure. Which ones?
Which one?
The board, you decided. I don't think it should be sexual misconduct for a starter.
It should or should not?
I don't think it should be people who are over prescribing.
I wouldn't list it as, we want to exempt these categories. I would say.
We want to report these
Categories that we want to report
Report.
are X, Y, and Z.
So,
Can we decide on what we're gonna report?
sure.
Felonies.
Felonies,
Felonies,
Criminal conviction.
criminal convictions.
criminal conviction.
They had, can you read them those?
Negligence.
Do we want negligence?
Sexual misconduct.
Sexual misconduct.
drug or alcohol abuse during practice, so
That's
intoxicated
reasonable,
while.
right?
Yes. Substance, just put substance abuse during practice.
Okay, and I think that was it. But Claudia is saying she likes negligence.
Or malpractice, if you're a doctor that's.
Yeah, that's a little, that's a little, that's a
Well, that's good.
It's a huge category that.
Oh, man, that's a pain in the butt.
That's the word that most of the public uses.
Well,
That's like the buzzword, so how
Yeah,
do you?
negligence.
Malpractice is like,
Yeah,
well,
malpractice.
it's like if you talk to the common patient, they're like, okay, negligence, and they're like, oh, no, malpractice.
How about-
That's what they hear in the news.
Sure, but not malpractice cases, but malpractice
Conviction.
conviction, is that the right word? Is that the right
Well,
word?
the malpractice cases,
No.
we review all the malpractice cases that come in to determine whether there was an actual violation of the medical acts. And so.
Okay, so you could say malpractice.
I mean, the issue is some people settle because they don't want to go to court, and it's,
Right, I think if we say malpractice, that's gonna open a can of worms,
Okay.
because the consumer's gonna say, oh, he had a malpractice
Right,
complaint.
that's the buzzword.
Right, it's a buzzword, and so the board didn't take any action on it, so the consumer's gonna go say, hey, you guys are not doing your job.
Okay.
As many cases closed with merit, they involved a settlement of malpractice,
Yes,
we settle just as many without merit.
you're correct.
They settle them as a matter of convenience.
Sure.
I got 4: felony, criminal convictions, sexual misconduct, and substance abuse
During practice.
during practice.
How about that as a start?
Drugs during practice.
That's
Well,
substance
it's
abuse.
Taken out of all substance abuse.
Can we offer that as a start?
You do malpractice if they're the ones with merit.
You want to do
But how do
malpractice
you-
with merit?
If they were settled with merit,
Yeah, but they're not
But
placed
that
on
becomes-
probation.
They're not on
They're not on
probation.
probation, we're only talking about probation.
That's true. And that becomes a very subjective
Yeah.
category.
Just like the word negligent, you know, the doctor wasn't nice to me, he was negligent. No, the doctor was in a bad mood, and he wasn't nice, he's got nothing to do with it. So I don't know if negligent actually, that's kind of a buzzword too.
So we had a first, we had a second, we had discussion, we came up with our list. Can we vote?
Call the question.
All right, Dr. Spino,
Yes.
Dr. Lally,
Yes, ma'am.
Dr. Kumari,
Yes.
Dr. Jensen,
Yes.
Claudia McConnell.
Yes.
I vote on the last one, the Claudia goes first.
Okay. Now, are we done with 798?
Yes.
Is that it? Thank you, everyone. That's a lot we got done.
So what are the next steps, just to like register, so this is gonna go forward and we're just done?
We're going to,
We hear.
Oh,
it.
next step, yes.
They're gonna-
Okay, so we have, now that the board has a position on all of these 3 issues, we will be conveying that position to the author, and we're gonna have to design wording to accommodate this. So for example, the fee, that's an easy one, that's like one word. Now, the author could reject that, so then that would be at it. The training one, then we'll have to just find all the sections and put wording in that doesn't include us. And then the notice to patient would probably, we would offer amendments, plus we'd write up a letter that says, you know, that we support different aspects, and to amend our support from the last letter, and raise concerns over this probation notice to the patients, and offer support if amended, and then offer the language. And so what the board, in taking a position, gives Angie the ability to know what she needs to do to negotiate with the legislature and come up with the wording. So we're not coming up with the wording today, but she has, just like we did the last time, we have the authority to implement what the board has decided to do policy-wise. So then you won't get, you know, it all happen essentially before the next board meeting. But Andrew will be able to report back our success or failure in any or all aspects.
The rest of the Senate bills,
Yes, okay. So, let's take a look. I'm looking at just the bill list for now. I've included both the language and the analysis for each of the bills, because oftentimes the wording doesn't strike through what's going on here. The analysis does give you an idea of not only what they're trying to do, what the intention was, as well as who supports or opposes. Okay, so this one, the 505, they prohibit the board from entering into any stipulation for disciplinary action if the stipulation places a licensee on probation and the operative accusation includes specific acts. And they list what specific acts. And we brought this to your attention because this really impacts and sort of is an overreaching move by the legislature to influence what normally is the board's authority to regulate discipline. And they're saying, essentially, they're feeling, and I think this is maybe what you heard the testimony, they're feeling maybe in reaction to the medical board's version of discipline, that they think, okay, well, maybe too many people with more serious cases should probably have not been put on probation, they should have just been revoked. So what they're doing is trying to take away that option. But the twist is, this bill is sponsored by the CMA. And we shook our heads and wondered the same. And what it essentially does, in saying that you can't enter into a stipulation, it's forcing hearings on cases that would otherwise be settled. Now, the idea with settlement is it offers the benefit to both parties of saving the litigation costs and coming to an agreement. In some of the stipulations, there isn't necessarily, an admission, a full admission. There's what they call soft admissions. And so I think they're wanting to have cases go before ALJs, and this is a cynical interpretation, because they might have a better success with ALJs than boards. But you all have the ability to overturn ALJ decisions. So it's kind of it's a very weird bill in terms of its motivation and range, but it really does a direct shot at the board's enforcement authority. So I felt like we should look at it, talk about it, see if you want to take a position. You don't have to. Maybe the bill will die, although it is on consent in the appropriations, which is a sign the bill is moving, so it has support. If bills by this time are not in that stage, they probably don't have the political muscle. This one could. And so that's 505. I don't.
I do believe the accusation has to include some certain criteria before we cannot go into a stipulated probation.
Right. Now, one of the things that Angie pointed out is that it doesn't affect revocations and surrenders.
It also doesn't affect a lot of cases that we place doctors on in stipulated probation. It only affects felony convictions resulting in direct patient harm, alcohol or drug abuse resulting in direct patient harm, or sexual acts or sexual exploitation. This bill would effectively prohibit probation from being offered as a means to settle the enumerated accusations unless an investigation has been completed and reviewed by a judge. So it's only certain certain violations that we cannot stipulate. So it's not all probations that we can't stipulate.
Yes, ma'am.
If my memory serves me correctly, this was the California Medical Association's proactive attempt to address the issue that Jerry Hill would keep coming up with about probation, about requiring the notification. So they were presenting a bill as an alternative with the thought that he might come back with a separate bill about notification of probation, not knowing that he was going to stick that provision in the sunset review bill.
Wow. Well, that kind of makes sense.
Thank you for that background.
So we don't have to take a position, but I felt like the board should at least entertain the bill because it does directly go into our enforcement authority.
Yeah, let's take a little break. It's
Okay.
warm and get a little hydration, stretch your legs, and we'll come back.
Okay.
Otherwise, we're gonna lose a quorum.
Yeah.
Anybody else wants to go?
Thank you all for taking a break. Okay, what's our next
Okay, so are we taking a position on 505
Are we taking a position on 505
or not?
as a position? I don't hear any outcry.
Enforcement costs. Will significantly increase enforcement costs?
Yes.
What's MPC's?
Well, it would, to take away the opportunity to settle, would raise our enforcement costs. I think NBC's estimate was for them, 3.4 million. We don't have a fiscal estimate for us, but given that we're already hitting the finish line at the end of the year on our budget and worrying about our enforcement, this would really take up potentially cases, impact, would take up cases to hearing that we wouldn't normally take to hearing.
Based on that they're opposing?
Yeah. Well, I don't know if they're opposing. They came up with a fiscal on it. So I don't know if they're trusted. So political decision is, you may not like it, but do you want to oppose it and go on record?
Not at this point.
Well, can I ask, how many cases do you guys have that relate to felony convictions, felony confrontation, safety, and, you know what I mean, like those
Sexual
three?
misconduct is kind of couple.
Okay, because then how much would it really impact your, I'm not saying that you should or that you shouldn't, but I'm just kind of curious. Is it a big number or?
No, it's in the report.
Very small, very small. Well,
In
I
your
did believe,
report?
I think, did it not say sexual
Because
misconduct?
fiscal, I mean, just from what I remember, you guys don't have a ton of discipline anyway, but maybe there's a lot that I don't see here that I wasn't seeing,
Drug or alcohol
you know,
use,
because
direct-
it didn't get that far.
Convictions
Sexual
that
acts
are
or
actually-
sexual exploitation.
Convictions that are actually
Involve
disciplined.
You know what I mean?
modification.
Yeah, so I'm trying to think of how many cases I saw when I was your attorney that,
Well, in the
that
report I
is-
gave it earlier today, just gives you how many conviction complaints we had that were, I can't remember the number, but 35 in the last quarters.
But it also indicates resulting in harm of patient
Patients.
safety.
But
And this be
very
a felony.
minimal.
so this doesn't seem like it would be a huge number, especially given your small licensing population. I don't know, I just was curious for my own education, I just,
Well, it certainly isn't gonna be a huge impact like the medical board, of course.
oh, of course,
Um,
yeah.
But as tight as our enforcement budget is,
It's
two
gonna-
of these cases
We'll
will
send you over.
send us over,
Absolutely.
absolutely.
Yeah, I was just curious.
Okay, next bill. Okay, 572, this bill would prohibit the boards from taking disciplinary action against or otherwise penalizing healing arts licensees who violate those provisions, but correct them in 15 days if there's no irreparable harm. This is one of two bills that attempts to give some kind of an opportunity to correct without having any consequences. The other bill that is moving is exempts the Healing Arts Board, so it doesn't apply to us. This one does, and it was originally a bill that I think they were targeting boards that oversee like pharmacies and things that they inspect. And so if they went there and found something wrong, non-compliant, and they gave them 50, and they said, if you correct this in 15 days, we won't issue a citation. That's the gist.
Fix it, fix it, fix it.
Right, like a fix-it ticket. Okay, so, the thing about this is that it's a policy that rewards people that are non-compliant. And it costs money to be compliant. And, you know, from a policy position, to try to change the world of enforcement for those that are not compliant as opposed to those that are compliant, compliance costs money. And you're rewarding people that don't spend the money for the enforcement and in favor of the people that, you know, are non-compliant. Now, I think the author, who was not willing to budge on the issue, because I talked to the staff, he believes that, and he didn't want to exempt any of the healing arts boards, he believes that it'll increase the enforcement. You know, because instead of having someone decide not to enforce a citation, for example, they would suddenly enforce it within 15 days. What it would do to our enforcement system is it would create a kind of notice category for issuing a citation. So normally, if we discover somebody's non-compliant, we would issue them a citation. It has, the basis of what their cause of action is, the facts that we know, and what we're asking them to do. Usually pay a fine and correct it. So now we have to discover that and then kind of send out a pre-notice that says, we've discovered that you are non-compliant for the following things, and you have 15 days to fix it. And if you don't, we're going to issue you a citation.
What is a direct application to us? What's a good example of that? How it would apply to this?
Not filing a fictitious name permit, advertising, that type of thing.
On the citation end, which are less, maybe egregious violations, compared to the other kinds of things that we put somebody on probation and just.
We just had a doctor who knew he had to have a fictitious name permit because he's had one in the past, did not renew it for 4 years, and then we found out that he was still advertising that name on the website. So we decided to find him, and his excuse was, well, I didn't know I had to have a fictitious name. No, you did, because you actually had one to begin with. Now, in that case, we would have had to give him 15 days to reapply or, catch up on his delinquent, but instead, we were able to cite and fine him. So that would be the difference.
And you do make income, there is some income to the board
Right.
on citations.
Right.
So I say,
No support.
Oppose it?
now, it
Oppose
broke
it.
by fixing.
You want to oppose it?
Oppose it.
Oppose
You
it.
make a motion to that.
Please, motion to
Is
oppose.
there a second?
Second.
Any more discussion? Vote, please. Roll call.
Please hold.
Official roll call. Dr. Lally.
No, I started backwards, thought I heard.
Okay, there we go. See, I got her too.
Yes.
Yes.
Dr. Zuniga,
Yes.
Dr. Buhari.
Yes.
Dr. Jensen,
Yes.
Dr. Lally.
I'd be last.
Okay, next.
Okay, 762, this bill would require OMBC to create a volunteer license, waive the fee for those becoming active or inactive, and the bill language is voluntary unpaid service to a public agency, not-for-profit, institution, or corporation that provides medical services to indigent patients in medically underserved areas or critical need populations of the state. It creates basically a loophole for our CMEs and competency with no defined period. And so one of the concerns is that this board doesn't have a voluntary license category, and because I don't know what if you not considered it, but one of the slippery slopes that a volunteer license category brings up legally and regulatorily is that there's no requirements, and everybody that's licensed to actually hands-on provide care is, has the CME requirements and the competency requirements. Yes.
Maybe this was, doesn't B say that you have to do CME requirements?
Oh, yes, sorry.
Sorry, I think either I misunderstood or, okay.
Yes. No, there is a minimal 1 year. It's
Okay.
a minimal requirement, not the same as our licensure. And it doesn't address if somebody's been out of practice for any period of time, 10 years, 20 years, whatever. So, and what it was, the intent behind the bill is the author's trying to create the, trying to meet the demand that is unmet in terms of providers. And so he's creating like the volunteer doctors who work for indigent care.
But how can they practice medicine within the force? It requires that the holder of an inactive healing arts license or certificate issued not engage in any activity for which active license or certificate is required.
Unless they work at those institutions, so they're driving them to indigent care
That's what's
So you're
existing.
giving indigent care substandard care.
Move to
That's
oppose.
what I was gonna say.
Move to oppose.
Is there a second?
Second.
All right, let's take a vote.
Opposed? Yes.
Okay,
We
no,
voted
yes,
to, we
Dr.
voted to oppose, right?
Yes. So I apologize.
Yeah.
The response should have been
Yes, oppose.
thank you.
Dr. Zuluaga,
Yes, oppose.
Dr. Bernard,
Yes, opposed.
Dr. Jensen.
Yes, the vote.
Next, please.
Okay, there's a 703 is a fee waiver. It requires board to grant a fee waiver to the spouse of military, a spouse of active military for initial license if licensed elsewhere. Bill is not moving, but it's in a series of many military waiver type fees, and one of the issues with the way that those have gone into effect, they were in response to a survey and kind of study that the Little Hoover administration or Little Hoover group did that said, oh, there's a problem with military serving and coming back and integrating and being able to support their family and get a job.
I'd like to call on Dr. Lally, a retired military man with lots of distinctions and others.
Yeah, I support this on the sense that they're gonna be moving anyway, so they'll be here for a little period of time. I mean, come on, they're in the military, they already got a crap deal, why are we adding extra fees?
That's what it is.
I would move to support.
Is there a second? Roll call.
Dr. Alden,
Yes, ma'am.
Dr. McCarty,
Yes.
Dr. Zuluaga,
Yes.
Dr. Bernard,
Yes.
Dr. Jensen.
Yes.
Thank you. Next item.
Okay, 845, authorizes the physician prescription of cannabidiol.
Cannabidiol, it's
Cannabidiol?
the CBD component of marijuana.
Okay, for medical purpose if the federal authorities exist. And so this one is, as you know, physicians don't have prescription authorities, recommendation. Okay, so this is trying to move forward with the state's cannabis regulation and legalization laws to also provide a formal authority for prescriptions. However, and of course it's contingent because this issue is contingent on federal law, which right now is increasingly against the state's action. And the reason I brought it up is not just because cannabis and the regulations are moving forward, but it poses it doesn't really resolve the issue that often physicians are asking about. Like, if I do this, do I have any liability? Well, just because it's in state law doesn't mean that you're not liable, because federal law will trump that. So if federal law and the U.S. Attorney's Office are busting people for illegal use of prescriptions, this law would not protect physicians. But it does say, the caveat is if the authority to prescribe this exists. So they're anticipating changes at the federal level, that if it does, change and it's a different schedule and it's not, legal, then you'd automatically have a clear prescription authority. So it's a little bit before its time. It doesn't overpromise, but it doesn't resolve any kind of conflict yet that we have on that issue. Conflict between state and federal law.
End of discussion.
Is there a second?
Sorry, so, give my first.
Yeah, well, then we move it
Did you
along.
second?
Then we let it go along.
Did you
I'm
second?
a little, no.
Well, we got a
The second
to
that we
talk
can
about.
talk.
Oh, okay, got it. Second.
Yeah, I was.
We just have discussion.
We're having a discussion.
Sorry, I missed that.
So if I may speak to this because of the VA. The VA is authorizing the use of the CBD component of marijuana for the use of post-traumatic stress. And they're encouraging their physicians to use it with those veterans that go through a psychological evaluation, clear to medical issues. They're trying to get them off of opiates. They're using the CBD. So everyone knows THC is the part that makes you happy. The CBD is the part that makes you calm and actually has a pain derivative to it. They have an oil out now. They use it for seizures for little kids in Colorado. The fact is that we can't do anything about this unless they take it from a Schedule 1 to a Schedule 2. And so it would just prepare us to be in a more favorable position when the federal government moves to do that. So right now, the anticipation is Trump's ignoring it, Sessions is opposed to it. However, the FDA has 3 companies that are pushing through with the phase 3 trials for this. And if one of those gets accepted, it automatically takes it from a Schedule 1 to a Schedule 2 without any bureaucracy. So it just sets us up, because we can't use it if the federal government doesn't support it, but it would be more of a proactive position to have, not to take anything away from my esteemed colleague who's going to speak against that.
Well, my concern is just, again, public safety, and I feel like the state hasn't done enough to put regulations in place, another bureau that's gonna
The
be
Bureau of
regulating.
Cannabis, yeah,
But, in terms of, the cannabis that's out there right now in the market is very tainted with pesticides. There's no critical limits set
you're correct.
that tell us if even the dose is gonna be safe for consumers.
Right.
And this acts as an emergency bill where if things were to change, the immediate, this would take place immediately.
Correct.
Is that what I'm?
Two little caveats. They issued a 211-page explanation of the rules last Friday that the government has put together because of Prop 4 and then the MRSA, which is the Medical Marijuana Act, which has been around since 2006. Within that 211 pages, they are spelling out the quality component of the marijuana to the proportion of mixture of THC to CBD. So this probably was written before the rules came out, because the governor recognizes that he may have been a little bit in a hurry, especially with the recreational part, but the marijuana medical part's been around since 2006, and that's a very tight control issue. And again, I'm not disputing what you're saying, but I would just go back and offer again that none of this is relevant if it's not changed from a Schedule 1 or anything else.
And the bill, the way it's worded, takes that into consideration, that none of it goes into effect until the feds provide.
And this only talks about epilepsy, right? So this would be only giving people with epilepsy?
Well, right now,
That's just what I was trying to say.
and they use it right now for kids. Colorado is big on the issue of epilepsy for epilepsy.
On mine, I had it,
Yeah.
originally for his daughter.
Yep, we finally found a cure for it, because she was having 10 to 15 a day, no matter what they had her on. She gets a little oil, and those are fine. Yeah, it's okay. So, when we call the question,
I'm going to fix the nails.
I know, I saw that.
Now, you notice the support is all related to the epilepsy. It's not, doesn't have,
Okay, we've got a first, we've got a second, we've had discussion, any more questions?
Just for epilepsy.
Let's go ahead and, vote.
And now it's gonna be like a pharmaceutical standard,
Yes, when it's all said and done. Right now, for the kids doing the
but you
cannabis,
have to be approved by the FDA
but it'll have to be approved by the FDA.
with all the, so I'm just worried about maybe some of these cancer entrepreneurs jumping in and saying, great, now we can use CBD.
Well, they do that anyway. So this adds, if you really think about it, the state's being smarter than Colorado, because come January the 1st, unless you are licensed by the state of California, they have an action against you now for having a clinic. Right now, you can just set up a clinic anywhere you want, and take your chances with the locals. If January the 1st comes around, the state has not issued you a license, they have the authority then to close you down, because it's gonna be a felony to be operating one of these.
And then they can audit you, make sure
And
you
they
have
will-
FDA.
and that's why they want to do the medical clinics for the audit. I'm only, and just so everyone as a disclaimer, because I'm trying to open up the VA clinic over here on this side of town. We're in weekly discussions with them about what to do and how to do it. And these are the assurances that they're trying to provide for safety.
Okay. Call.
Auditor Mercado?
I say yes.
Yeah, before.
I welcome your yes, but you can say no.
And I say yes.
Dr. Vincent?
Yes.
Dr. Kumari?
Yes.
Dr. Holly?
Yes.
Dr. Zumbo?
Yes, please. Okay, next.
Okay, so that ends the ones to consider taking a position. The rest are informational. I don't know if you want me to go over them or you've read them. I put them on the list because I thought you should be aware, for example, that there's another bill that has cannabis research for a lot of clinical trials, just for the sake of information. The opioid work group is with public health heading it up, is going to be there, when all of you are very involved in different aspects of it, so I just wanted you to know. And then this one about prohibits gifts from manufacturers to physicians, travel, CME conferences. That's also a bill. And then an urgency clause for the cures, and that cures bill, the AB 40, seems to be to allow emergency room physicians to be able to have their software connected to this database.
Why wouldn't they want that?
They want it. This is they're wanting, but I guess they were left out, or they are needing.
I didn't know that.
I think there's a, it's not that there was a list of
You
physicians,
don't have
but,
cures.
well, I think they have their own software, because there's language in the bill that talks about third parties, connectivity.
I see.
And so I think it's more of an IT issue and kind of a, like, who has the right to plug into the system that's currently run.
Can I make a recommendation on SB 790 that they change that to assemblymen and senators, not get gifts?
I think so.
I mean, we're down to $25 for a dinner, that's all you're allowed. And a pen.
Why can't you get a pen? Why don't you get a pen?
No, you get a pen if the girl fills out the paperwork.
Oh, I got a pen from hospice. I'm only gonna eat.
And the $25 only for dinner.
Okay, next, number 10, Title 16 California Code of Regulations, discussion and possible action to consider amendments to the California Code of Regulations sections.
Okay, so this is continuation from the last board meeting where we agreed that we were going to ask the senator to carry the bill to change the 2454.5, I guess it was, to change it from the 150 to 100, 3 years to 2 years. So now that that's been approved, we brought the proposed language for a regulation back to you to get an approval. We had this at the last meeting. Our legal counsel at that time thought it was too premature to discuss this because we wanted to make sure the statute was going to be changed before we brought the regs.
And it wasn't really
It was Jason.
It wasn't me.
Yes, it was Jason.
Jason's awesome, so,
Hey, Dr. Zulu.
you got a good one.
Kathleen.
I'm sorry, Kathleen, I didn't mean to.
No, that's fine. I actually have a comment on this issue, if this is an appropriate time.
Yes, please.
Very, very supportive of changing the timing of the CME requirement. I think that will be very helpful for everybody involved. My concern with the proposed verbiage is that it does not include any minimum percentage of records that will be audited. So right now, we're doing 100% requirement. As it's written now, it would be just an opportunity for audit. And the board in January agreed that it would be appropriate to have a minimum of 50% of records audited.
Right,
per
but
year.
didn't our legal counsel, oh, it's not her, Jason, tell us that? I thought Jason told us that we shouldn't put
We
a,
should leave it out of the regs.
yeah, we can do it, but you just wouldn't put it in the regs.
Where is, oh, I'm sorry, do you know, can you tell me which section the audit is in?
No more than.
Right, exactly.
Like, I mean, if I could see the language, then I would maybe have like some feedback.
Like where it would go. So on page 2, if you're looking at the language, amendment to
Is it-
subsection C, 1636. Shall
Okay.
be subject to an audit of their CME hours.
My question is, does my clearinghouse project take care of that audit? Saying that 100% of everything that's reported is reviewed through AOA?
Under this verbiage, nobody would have to look at that clearinghouse report. The physician could submit it, but doesn't have to. All they have to do is check the box saying, yes, I completed my hours. So nobody
At
would
the
even
time
have
of
to see that
renewal.
report.
At the time of renewal, the staff will review that form that's signed under penalty of perjury that they've completed the required amount. At that time, they get renewed. Then they get called for an audit at a later date, at which time all the CME will be reviewed. Now, the AOA CME would be still a perfect opportunity for, I mean, it'd be much easier for the.
Because it streamlined the
Yeah.
whole audit process.
Right,
Great.
right. But I don't know that, I'm not sure that we can force non-members to accept this track CME. I think it's a good opportunity for us to let them know that this is available, but I don't think that we can force these physicians. So we may still be getting doctors that are gonna be submitting 150 different, or 100 pages, I guess, now that it's not 150 anymore.
So to address what Kathleen and what legal counsel in the past has recommended, generally, you don't put percentages in regs for compliance.
Okay.
From a daily operations thing, what Angie and I looked at in terms of what we do now in the 100% and what we would do under this, is the 3-year period now is done in a 2 times 2 4-year period, 2 renewals. So the second renewal in a 3-year cycle is when we look at whether people comply with the 3 years, right? Okay, so that's 4 years. Under our evaluation, what we would do, we assess workload-wise, we would do a minimum of 25% each year, which at the end of 4 years would be 100%, which is the same as we do now. And our goal is not to lessen our standard, just not to put the percentage in the regs.
So, but if we don't write it down, how does the public know that we're doing that? I mean, what assurance does someone know that we've done an audit on that?
Well,
The public doesn't know.
doesn't know right now that we review CME,
Well, they don't.
unless they read our regs.
Right, so what I'm thinking is, okay, if I understood you correctly, you said that basically every year the board would do 25% of, right? So basically, if you put it in the, either the ISOR or the notice or something in the rulemaking packet that explains, then you've kind of put it out there for whoever's paying attention to how many you're doing.
I think
is
the-
that
the
If
reason
you
we like the
put
rationale.
it- if you put it in the, just the ISOR, or you put it in the regs?
No, not if you put it in the regs, but if you explain.
Oh, I see, as the background
Yeah.
for it, then it would be out there, okay, what you're
Yeah,
saying?
so granted,
Yeah,
you'd
yeah.
have to actually go and pull the rulemaking file 10 years later if you wanted to find out what the rationale was. But,
So she's presenting, just technically, when we would do these regs, the one that has the actual language would not have a percentage in it, but also that accompanies that is an explanation of what we're trying to do. It's gotta be understandable to the public, and that explanation could have these percentages.
Dr. Kirkman?
Talking about evaluating 25% every year, what are we evaluating?
Compliance.
Right?
Compliance. Do they have all of the documentation required to show that they met?
Where does it say that?
Let's see.
That's part of our background.
Here, it's,
It's non-compliance section 1641. And if any physician who has not completed the 150 hours of approved CME during the 2-year CME requirement period will be required to make up any deficiency unless a waiver is obtained pursuant to section 1637. Any physician who fails to complete the deficient hours shall be ineligible for renewal of his or her license until such time the CME documents are documented to the board.
So, physicians in CME, and after 2 years, we check to see if they did it or not.
No, we audit them. Whoever gets picked for the audit will need to submit the CME for that required period.
Where does it say what they have to show us to show that they've done it?
In C, it says, shall randomly audit physicians who have reported compliance, which is the yes, I did checkbox. Those physicians and surgeons selected for the audit shall be required to document their compliance with CME requirements as specified.
What does that specify?
Hold on, under section, under
Specify.
page 2 section, it states, they'll be subject to the audit of their CME. Each physician shall retain all documents that demonstrate compliance, such as a copy of their computer printout as compiled from documents of the AOA, sponsors and physician individual activity report, and copies of any certificates given for CME credit hours in the time period involved. Reports from any program approved by the board to be furnished by the physician. So it's on page 2.
That answers the question.
Thank you.
Next thing is, what is this very result?
What happened if they don't?
They don't show that.
They don't get renewed.
They don't get renewed.
So then they would be unlicensed as of their expiration date. when they come up for the next renewal.
So even though they do it, they can practice for a couple of years.
We should, yeah,
It's at the time of renewal, Dr. Kirpin, that they're gonna do this audit.
They weren't audited the first year or the second year, they didn't do it.
Dr. Kirkland, we're
They're
not,
practicing without it.
we're reviewing way later. I mean, right now, the current CME cycle that we're reviewing is 2013 through 2015. So these doctors could have been practicing without any CME for all this time. So this is going to be a lot more stringent on the requirement of CME. Because right now, it's taking a 3-year lapse before we're actually reviewing this. Because the doctors are renewing every other
But they
year.
had to show 100% compliance.
Yes, they do.
Every 4 years, not every 2 years. Under our
When we
current system.
audit them, they will have to come
When
up
they're
that,
audited, they have to show that they 100% completed in 150 hours.
100 hours.
100
Based on this
You can't get
documentation.
any more stringent than that.
No, no, they can't.
And we'll know sooner in the 4-year period. You know, 25% we'll know from the first year of audit, then up to 50% by year 2, which is faster than we know with our current system.
100% waiting 3 years or more right now.
Right.
Kathleen, you have a question?
I still have, I would still like to request that the board consider putting a threshold in the regulations. When I pressed Jason about it, he kind of backed off and said that he wasn't sure that there was actually a problem with putting a threshold in there. I'm looking at this from a public safety standpoint. If you're going to have, if after the wonderful staff that's here now is no longer here, if there's no requirement, then they may say that we can put all of our emphasis in some other area and not do any audit at all, if you don't have a threshold in there.
So are you suggesting a minimum?
So the reason you wouldn't want to put a percentage in a regulation is because a percentage dictates workload. And workload is daily operations, it's different than policy. And this is basically a policy. And so if for any reason there was a change in operations that made us either not meet the threshold, there wouldn't be any consequence if we exceed it, you have to change the regs. That's generally why you don't put specific workload details like percentages or achievements in regs, because then if you don't meet them or you want to change them, then you.
So you can't, let's say you can't put the percentage in the regs. You did mention earlier that there's a supporting document that goes with the regs that you could define in there the percentage that could be done.
Right, and
It's
that's
called ISO.
initial statement.
Initial statement of reasons, sorry.
ISOR.
Yeah.
So would that work, Kathleen? No, I'm
You could
just
do it as
asking.
for example, the board might do this. The board might do 25%.
Informational. What
Because
she's
what
asking
happens,
is
what
for-
happens if one year they only get 20% audited? And what's the board supposed to do?
Right.
Which was, ours.
Well, I mean, if you put in the regulation that that no less than 25% of licensees will be audited every year, and let's say the board becomes overwhelmed and we get a big influx of licensees, and they only get 20% done this year in a 365-day period. Now, what's the consequence? What's the ramification of that? That's what I think we're still striving to hit 25 or more, but to put it in the regulation is just that concern. So if they put it in kind of like a signing statement or an intention to achieve that, is that adequate?
Who's definitive authority looking at a reg? Like you quoted
anything can go in a
this,
reg.
and then Jason backed down a little bit when he got pressured.
Yeah, but it can go in. You can
It
put
can.
anything you
You
want.
can put it in.
Discretion.
You
Do you want
can
to
put it
box
in.
yourself
So it's like
in?
opinion.
Right, do you want to box yourself in, and also you have to justify why you've chosen that amount?
Right.
Why do we want to do 25%? Why do we want to do 100%? Why do we want to do 2%?
What percentage would you like to see, and then how would we put it in there? Kathleen?
Well, the board had talked about in January about establishing a percentage so that within a 2-year cycle, during which time every licensee would have renewed, 100% would have been on within that time frame.
Right, and that would happen because we've got 4 years for all doctors to renew because it's a 2-year license renewal right now. And if we do 25% every year, that's 100%. Everybody within every 4-year cycle will be audited.
You're gonna get audited once every 4 years, without fail. I mean, you could put that
If we do
into
that
regulation.
25%. However, and so, Dr. Buhari is correct, right now, our staff can support this 25%. But we all of a sudden have 1,000 applications and we have 12,000 licensees, we may not be able to adhere to 25%, might have to reduce it to 20%. If that happens, we have to rewrite the regs all over again. Everything that we change, I mean, everything that we can't comply with the regs, we have to go back and change it. So it would be best if we left the percentage out so that the regs stay in effect, and like Ileana said, that we could put that in our ISOR, saying that the board proposes to do 25%.
Well, and Kathleen, another thing to consider is that the board does get reviewed every 4, what's your sunset, every 4 years? Every 4 years, and some of those questions are, you said that you were gonna do audits, how many have you done? Oh, you've only done this many, okay, slap on the wrist. So the legislature can take care of, or can address any shortfalls the board may have in terms of that. Because the board does, does work in the best interest for, consumers, and I don't think that they would not be doing audits if it wasn't specifically set forward, you're gonna do this many. So I think that, I don't know, I agree with you that it shouldn't necessarily be in the reg, because it does set a standard that you may not be able to meet all the time, and maybe they can do more, maybe they can do less, but they will be doing it. So,
And just to put it in context, most other boards, their threshold is like 5% or 8%.
and I have another client that doesn't have any, they do regular audits, and they do quite a few, but their percentage is really low, but their reg also doesn't say how many.
Right. And so I think what our intention in moving to the self-certification and not trying to lessen our standard was to compromise that anybody that's non-compliant doesn't get renewed. A lot of other boards don't have that. So we retain that standard. And 2, we estimated that we could, in the same period, 4-year period, do 100% of the audits. So that means people are not falling through the cracks. We're not doing 8% in 4 years. Our goal is 100% in 4 years. So we feel like it may streamline our whole compliance program for CMEs, but still protect the public in terms of ensuring that people are doing their CMEs in terms of compliance. And the way the boards do the randomize, the reason we randomize and they do such low percentages is because randomly you don't know if you're going to be picked. So if you want to be not picked, you just better be, the best way to do it is just be in compliance. So the randomized as opposed to mandatory works. Now we still have with our mandatory people that don't do it, in our current system, and I anticipate we may have people that don't do it, in this new system. But now they're going to be subject to a cite fine of $1,000, plus they're going to have to make it up, and they're not going to get renewed until they do it. So we have more kind of penalty coming to bear in going to the streamlined system.
Would it also encourage them to get their CMEs done
Earlier.
earlier versus having to do like 100 hours?
100 hours.
That's what we were also saying was a kind of an unintended consequence, because we see a lot of completion towards the end of the 3 years.
Now, do we?
I have a question right now. If they don't get 50 hours this year, they get 40. Next year they get 60. They apply 20 retroactive, 10 retroactive.
That counts.
They're going to be able to do this.
Yes, it's 100 every 2 years, so it doesn't matter how they do it, how they divide it in the 2 years, but it has to be 100 in the year.
So
If we
You
check-
can spend the last 100 hours
They
with your
don't get
licensure
checked every year.
test.
They get checked. Some of them get checked after 4 years have gone by. Would we be checking them for the whole prior 4 years?
No,
just
the renewal period.
The
that
renewal,
we're
the
auditing.
first 2 years.
Some of them could get away under this system with not doing it the first 2 years.
No, because we will be auditing those first 2 years after the first 2 years are done.
Everybody will be audited every 2 years?
Every 4 years. By the end of 4 years, and when everybody has renewed their license, at one point or another, they would be audited, yes.
My question is, if we don't audit them for the first 2 years, they get audited after 4 years, are we gonna look back to the first 2 years and see that they're requirements?
No, the first audit cycle will involve the doctors that renewed the first 2 years. Because they would,
What about the ones we don't audit the first 2 years?
The second 2 years. The second 2 years.
You're suggesting, so if you have two groups essentially. You have a group that got audited in the first 2 years and a group that got audited in the second 2 years, the 25, 25, 25, 25. So the group that got audited in the second 2 years could theoretically have lied on the first set of CMEs and gotten away with it, is what
right,
you're
Dr. Kirkland is
suggesting.
saying, yeah, yes, that is true.
That's true, that's a possibility.
That's only once.
Yeah, they only get away with it once.
But you only get away with it for probably, well, I guess a maximum of 4 years, which is what the current, time period is now. Or you could get caught earlier through each of the year's audits.
So,
It's still an
after
improvement.
4 years, we will audit everyone.
Yes,
But they'll be audited for that cycle.
cycle. So then the next,
So
after
They audit for the
next,
first 2 years.
right,
But
right,
theoretically.
yes.
But I think it offers, this way still offers enough of a stick hanging over your head that you probably would try, because you don't know when you're gonna get audited, whether you're gonna be in
Right.
that first group or not.
Right.
So it's kind of the same effect as a possible random audit.
Currently, the medical board has a random selection of people they check on.
Yes,
You call them and
and a
say,
very low percentage.
8%.
you met like 10%. You call them and say, did you do your CME? And they say, yes. And it's a unit.
That's it.
And then they audit 1%
They
of
audit,
their licensees.
because my husband's been audited, he's an MD, and he had to, usually checks the
He signed
box,
here.
checks the box, and then they audited him once, and he sent them all this stuff. That's happened once in 12 years.
Yes, Kathleen?
So if I could just to keep the conversation moving along, and I hate to be the sticky wicket here, but I just, I want to make sure that, all factors are considered and that the public is protected as best possible. As long as we can document in some fashion, even if it's not regulations, if it's in the ISO document or whatever it might be, that the intention is to achieve 25% audit rate on an annual basis.
Which creates a 10%.
Can we also report on the findings as we go along in the audit, just to see what,
Yeah, so that could be a regular item at board meetings, like you look at enforcement.
How often do you see it right now?
What's that? How?
Somebody faking CMEs?
They're not faking CME, but at the end of here we are already in 2017. We're reviewing 2013 through 15, and they're asking for an extension.
Oops.
Yes. And so, I think this will eliminate that kind of stuff.
Yeah. And we don't necessarily keep track of how many, because the consequence is that they don't get renewed. And so then they're one of our delinquents for the CME reason.
Then you have to pay.
So is there a motion on the table?
Now we don't specify.
Is there a motion on the table?
no motion?
Second.
So the motion is to approve the language, but to add something to the ISOR,
You want to go through?
that the intention is for 25% per year and 100% of all licensees every 4 years to be audited.
Correct.
For it to be documented.
Correct. Is there a second?
Second.
Yes.
Yeah.
Dr. Jensen?
Yes.
Dr. Bernard?
Yes.
Dr. Lally?
Yes.
Dr. Wheeler?
I suppose so.
I want to be called first.
Okay, anything more on Title 16?
Yeah, so, not, well, we have another break. Okay. We're on the disciplinary guidelines, right? Okay. So, so we just did all of the bullet points from 16, 35, 36, and 41, and now we're on 16, 61, and 16, 63. And this involves our disciplinary guidelines, and this was a regulatory packet that was submitted to the Office of Administrative Law and rejected in December. And they gave us an option that we could withdraw and start over again, or they gave a grace period in which we can try to revise it
and make it better, which is what we opted for. And so one of the things that we did is we met with the attorney from the Office of Administrative Law to understand exactly why it got rejected. And then I wanted to explain that to you and give you, we're not going to be voting on the language because Jason did not have a chance to look at this, and he needs to be under the normal process, the one that
We're talking about
reviews
this document.
Yes. Not the one that we handed out, no, not that, the one that was actually in the packet.
It's under section 66. It's way towards the back. It's under tab A. It's here, the second yellow or third yellow under tab A.
Tab A.
Tab A, third yellow.
Okay, so before I go into the language, I just want to finish the overview of what we needed to fix. So one of the things, and also the timetable. Okay, so we were given an automatic extension until April, and I didn't have this new version done. So we asked for an extension, which brings us to mid-August, and I was hoping to have this reviewed by the board and approved so that we could, it has to go through many reviews and public comment for 50 days and back to you all before August. But unexpectedly, it took longer to draft, and Jason's not here, and so what I wanted you to do is be familiar with this Ask Questions Now, both for Liana or myself, because we'll have to do a phone call for once we get the final language. So the gist of this regulatory packet that we got, the feedback is that we created, the uniform guidelines was a mandated set of guidelines of 16 guidelines. And they were just kind of a mix, and they were mandated to be put in our disciplinary guidelines, and our diversion committee has to follow them. Okay, the way we wrote it is we said, oh, we'll just incorporate it twice. Then we used our guidelines that are not promulgated, that have been updated through the years, but not actually legally promulgated. We haven't legally updated our disciplinary guidelines since 1996. So in revising this, I had to go back to our 96 guidelines. So everything is new. Not everything, but a lot of the stuff is new in terms of what we updated since 96 that was in our existing package. Another issue was that in creating a standard that you have to follow, mandated, i.e. you have to follow mandatory guidelines, in the context of disciplinary guidelines where the board has discretion, what they do for discipline, the attorney said, you can't mandate, just say you mandate in all cases, and then you also have discretion. He said, so I'm confused. When do you mandate this and when do you not? Okay, you got to explain that to me in terms of the organization. And you got to tell me when is this triggered. Okay, so my attempt at doing that was to, the first language I think that you get is the 1661, your diversion committee. I just took out the words incorporated by reference. Because his advice was to integrate them into our disciplinary guidelines. Don't what they call incorporate by reference. It's like having it printed twice is what we essentially did when you say incorporated by reference. So I just said you have to follow the disciplinary guidelines. Because now the uniform guidelines are in there. Okay? So that was one of the changes. So the other change is I created, if you look, well, let's look in order. If you look, there's the language following the diversion committee in 1663, which is underlined, and I'll address that in a minute. And then we have a quarterly reporting form, which would be effective 8/17, and if you look at that, the one in back of it, which is 597, effective, look very different. So we're upgrading our quarterly reporting form to ask much more effective questions. Okay, so that will be good. So if you then pass beyond that and go into what has a cover sheet of the disciplinary guidelines with table of contents, most of the existing guidelines are the same. And what I did is I created parts.
sort of like to tell a story. Part one is your overview. So for a user trying to make these guidelines user-friendly, so your part one introduction, that's the same. I added, I started to add what disciplinary guidelines are, terms and conditions. It was a mixture of just trying to organize it and existing language. That's part one. Part two is new. That's where I incorporated the uniform guidelines. The lawyer said, don't have them separate, put them right into your disciplinary guidelines. So now they're incorporated as of part two. But this language in part two starts to describe when the standard applies. And that goes to the heart of what he said we did wrong. Okay, so I just want to read you the first parts of part two. So it talks about the uniform guidelines pursuant to 315. This is a professions code where they develop standards for substance abusing licensees. Okay, the lawyer said, what constitutes a substance abusing licensee? If you say that you use it only for a substance abusing licensee, how do you know who's a substance abusing licensee or not? He said you have to answer that question. Okay, so then the second paragraph, to the end, unless the condition is permissive, noted each of the following probationary terms must be, I'm on page 7, for anybody that's still looking around. They must be used in every case unless the condition is permissive. Uniform guidelines, as noted below, each of the following probationary terms and conditions must be used in every case where the violation involves the use of drugs, alcohol, or both. Despite this requirement, appropriate additional options should be used to formulate penalties and additional terms and conditions. Okay, so that's my attempt at trying to give discretion for the board, but they have to mandate, they have to use those disciplinary guidelines. But in cases where the use of drugs, not just drugs and alcohol, because we have violations that just involve drugs, but they don't necessarily all involve the use of drugs, right? So the guidelines wouldn't necessarily be required unless there was some cause of action related or evidence that they were using the drugs, okay? So I was careful in defining when. Okay, if the conduct, this is the third paragraph, if the conduct is found to be in violation, and the violation involves use of drugs, alcohol, or both, a clinical evaluation shall be ordered by the board as a condition of probation. This clinical diagnostic evaluation determines and defines whether the licensee is in fact a substance abusing licensee and therefore subject to compliance under the uniform standards for substance abusing licensees. In the case in which the clinical diagnostic evaluating report finding is that the individual is not a substance abusing licensee, then the remaining provisions of the uniform standards may be waived. The violation did not involve the use of drugs, but the facts in the case suggest terms are warranted, the conditions may be applied to ensure the public is protected. So the way this is written, we have two violations regarding use. Those are the two that I have tagged as requiring the uniform use of the uniform guidelines. And then the ones that have drugs involved, but not necessarily used, I have added them but not required them. So the board has them as a tool. Big organizational change that I do believe will satisfy the issue that was raised by the attorney. That's one. Okay, so then if you keep going, here's the uniform standards, just verbatim.
Page 8, 9,
And it would be from
It starts
One.
with 11.
8 to 34.
11 through 50? 11 through, yeah. 50?
No, standard 16 to 34.
34,
Part
okay.
3 starts on page 36.
Standards.
Okay. Okay, those you've seen before, those are unchanged, but now those are in section 2, and it solved one of the problems, which was, we didn't include all of the standards in there, in the first one. And the reason we didn't is number 16 has administrative data requirements, which has no connection to terms and condition and probation. But we're still required by OAL to include the whole standard. So the way that I solved the problem is just creating a section in our disciplinary guidelines and incorporating 100%. Boom, now it's 100% in our guidelines. Okay. So then moving to section beyond that, I guess it must be 36, what is, or there's part 3, model language. Okay, so then this is where most of the language is the exact same that we approved for the first packet. But the attorney said incorporate and make sure you have uniform guidelines in this. So I did. And so if you look at the terms and conditions, there is only one thing new. If you look on page, what is the first, what page numbers, your part 3? 36. Okay.
36.
So 36, if you look at the standard terms and conditions in part A, there's a number 10, and it says supervision of physicians, assistants, and advanced practice nurses. That was not in your original package, so I want to bring that to your attention to see if the board is wanting to add that. It's something that the medical board has that we should have in here, but we have not. And so it's an opportunity to add it. And so this is like in a probationary, because we don't have it in there, we can't in our probationary order say that DOs can't supervise physician assistants and advanced practice nursing. That language is in other boards' disciplinary orders, and it should be in ours, but it hasn't been, but it is a policy change, so I wanted to bring it to your attention.
Well, and just so you know, I mean, I don't know what the nurses one says, but for PAs, it says that a supervising physician cannot. Basically, it kind of goes backwards. It says your supervising physician cannot be a probation or being disciplined by a
Just be
or
good
like-
standard.
Yeah. So this just kind of makes it go both ways.
Yes, exactly.
Because you can't
Yes.
restrict it if it's not in there as an expectation
Right.
for treatment.
Well, and we can't put it in, we can't require it, so.
Does it require any decision on our part? I mean,
No, because we're not voting, but I just wanted policy-wise for when you do the phone call vote, that you know that most of the stuff is the same, but this is new. This is one of the new sections that
Is
we added.
it new in here or new here?
It's
New
the one
there.
that's in the packet.
It's in the packet.
So we don't need this one.
Well, that was, Ileana had gone over it and made some changes, so we brought the changes that she was recommending, but right now we're going with the.
And my changes are nothing huge. They're like, there's a part at the very beginning where I changed the language just to, I thought it sounded a little better, but
Because you didn't have anything else to do, or?
I was trying to do our homework.
But wait, I thought the Jason guy did this for us too.
He did.
I don't know what he did.
He hasn't seen this, so the problem
Right.
is that he was unavailable at the last minute.
Yes.
Ileana is stepping in and, to her credit, trying to kind of.
Well, that's nice of her, but I
Yes.
mean, if the other guy's supposed to do his work, why isn't he doing it?
He is doing it. He is legitimately out of the office for personal reasons.
Oh.
And so I didn't want to have not looked at this and have you had questions and and I don't know when he's gonna be back. I don't know what the situation is, so I didn't want to leave you guys hanging.
And instead of pulling this agenda item, I want everybody to feel good that they know what's going on, so when we do that call, we get the final language, you're gonna be thumbs up.
Yeah, there's
Okay.
nothing outrageous in anything here. Everything.
Okay, so the next change that's new that I wanted to bring to your attention is on number, I don't know what the page number is, but it's diversion program. No, not that one. It's the. Right, this page. Okay, it would be in, the number 3 under the model language that says drugs abstain from use.
I have a diversion program on page 49, where there's a whole thing about, it talks about the standards, the diversion of 32. On page 49.
On 49? Okay, my number is different,
Oh,
because that's what I'm
sorry.
asking. So I wanted to direct your attention to 33. Which page number is that?
Section 33 is on page 50.
So just go 3 pages back.
Oh, okay. Oh, okay. Okay, what I added, to clarify when the standard is this, is I added language, the parentheses says optional language. And this is language, model language that goes in our orders and our stipulations. This condition may be waived or modified in the board upon written finding that the clinical diagnostic evaluation of the respondent is not a substance abusing licensee. So he was asking, like, when did the uniform guidelines apply? Well, one, it's a little bit awkward to write this because by the time you get somebody into a diversion program, the diversion program is the mechanism that determines whether they're a substance abusing licensee, but you can't do that until you put them on probation. So it's a little awkward to figure out how to write this. Okay, so the way I got around this is for the use of drugs, and there are two violations. You have optional language that if, when somebody is put on probation for use of drugs, and then they go to the diversion program, which they're mandated to do, if in the evaluation it determines they're not a substance abusing licensee, we haven't had many, but we have some, then they're no longer required to finish apply with the other terms the board may modify that based on that. Because the order is kind of all-inclusive of all of these conditions without having actually tested the person to see if they are a substance abusing licensee. So what was problematic for the AG was they couldn't figure, not the AG, AOL, is they couldn't figure out when they were applied, and then if there's a flexibility, because after you've got to define them, like at what point are you defining them? It's that test that we require. The test isn't required until we already put them on probation. So it's a little awkward in that. So having this optional language say that it's not required if they are determined to be not a substance abusing licensee, again reinforces me when it applies and when it doesn't. So I have it in 33 and 34, also abstain from use. And have it in,
Here in other drugs.
yeah. The working while intoxicated one. I don't know what standard that is, and which number that is.
You said 36 already?
Yeah, that's alcohol, one is substance abuse, and then there's a intoxicated, we have a violation, intoxicated while working. Okay. so-
37.
37, okay.
I don't know if that's that one, but it's included in 37.
Okay. So then, the other thing, I'm just looking through this, where did we put how did we know this, it must be on the sexual, exploitation language.
Is that where you added the,
Third-party presence, is that?
third party? Yeah, there is.
Okay, third-party presence is 21. This is in the part 3 of the model language. It's 21, third-party presence.
Yeah, what does that mean?
And it's like a chaperone, monitor, but I left it third-party presence. The chaperone monitor have turned out, I guess, standards.
I'm sorry, Terry, what section?
It's in part 3, 21, number 21, third-party presence.
Page 44.
44, yeah. Okay, so we had, you can note that there is 3 paragraphs. We added the middle paragraph. And what we did is added, the respondent shall provide written notice to the respondent's patient that the respondent is on probation, and as a condition of probation, the respondent must have a third-party monitor that shall be present during the consultations, examinations, treatment, and then you would insert male or female minor patients, depending on what the order applied to. The patient must sign and acknowledge the receipt of the notice, and the respondent maintain a copy of the original notification in the patient's file, and shall make notification available for immediate inspection and copying on the premises during business hours by the board or designee, and shall retain notification for the entire term of probation. The practice monitor shall inspect patient records and confirm in a report to the board the status of compliance of such notice, and maintain a signed acknowledgement in the patient file. Okay, so that is something we didn't require before on the third-party presence, and it fills a loophole that we didn't have, because we can't require something we don't have authority to require. And so if we wanted the patient to have notice, if we didn't require written notice and it be in the file, the third-party present or the monitor, the practice monitor, wouldn't know, what to look for. I mean, they would know what to look for, but it wouldn't necessarily have to be in every file because we didn't put it as a requirement. So what this does is for third-party presence, usually sex inappropriate touching situations, it closes our enforcement loophole so that we can require compliance, patient is notified, and the monitor that is assigned is checking and reporting to the board compliance. So that's a, and the medical board has somewhat of this, but ours is a tighter requirement because we're requiring written, the notice the medical board requires is just notice, but, Cyrus, as you mentioned, how is it enforceable? Well, it's not, and, unless it comes up in an enforcement case. In this case, if somebody is on probation for inappropriate touching or behavior with the patient, and they're not revoked, and they require a third party present, our ability to monitor whether they're really complying with our probation is now strengthened because the patient knows, and we know because it's got to be in the file, signed, and then we have somebody that's third party present being able to look at all the files that they're supposed to be looking at. So I think it's a tighter requirement.
It actually goes along with the BPC that we were talking about, because it's the same, I mean,
Yes,
it's
yes,
this
it does.
particular
It does,
situation.
exactly.
It's when you have been found guilty of this and you're required to have a third party present, it goes along exactly with that BPC, that now you have to have written notice for.
Yes, yeah, so it is, yes, it's very close. So I didn't think we were doing anything,
No,
but it is a
consistent.
change. The board hasn't decided, but it's very consistent with what you approved today. Okay, so that was the two big changes, and I'm just looking through because I wanted to make sure, I identified changes that were major changes versus not. And the other thing I did was just trying to add, when a license, when a standard was used, I added that happens to be consistent with all of the different standards that it is consistent with. So that is, and then the back stuff was all crossed out, that's your 1996, last updated disciplinary guidelines. And then the last minor change was I added, consistent with the formatting of other boards, I added maximum discipline as revocation because we say it in our paragraph, but in our 1996, we only had minimum in there. So it looked a little awkward to not have maximum minimum, even though we stated maximum penalty would be revocation. Okay, so let me go back to the language, going to the very back, the front, what we talked about. The diversion committee was 1661, and then the disciplinary guidelines. You approved this language, and the issue that I have to make sure that is right is subsection C. When we start to integrate the disciplinary guidelines, this is 1663. I'm going all the way back to your front, very front. There's a 2, subsection 2, that's the stuff that you approved about the sex offense and revocation. But subsection 3, subsection C, is where the incorporation language of the uniform guidelines. That is something that remains, I need to have, talk to Jason about.
So
that.
C1 is new
Um,
in 1663?
Yes, okay. C1 and 2, and part of C is modified in the first paragraph, and that's it.
Okay.
And the rest is the same. So, questions?
I compliment you on your
Excellent work.
There is
Excellent.
It was a lot of work. It was a lot of work.
When do you think the teleconference might be?
It depends on, the teleconference with the board is just this. It's as fast as I can get with Jason.
Okay. I think he may not be back next week.
Ah, okay.
So I'm just kind of putting that out there because
Okay.
somebody let me know they were covering another one of his meetings.
Oh, okay.
So, anyway,
Okay.
so give me a call if you need to.
Okay.
I'm happy to answer whatever, do whatever legal stuff you need from me.
Okay, okay.
And so it's like we're looking for
And
August,
then
right?
don't forget that
I
Moshko's
still
gonna
have
need
to
10
post it,
days.
so I would still need 10 days prior to the appointment to conduct the meeting, so I have.
Yes, yes, exactly. So we still need the 10
Right.
days. So I'm guessing, we're in May, it's probably not gonna happen until June, but I don't know, probably towards the end of June or mid-June, realistically.
Earlier, we were talking about violations that would cause us to notify the public that we're on probation, and which ones were cases that should be considered. After we read to page 3, the list of the
What page down?
different violations that can be used as a guideline for determining which ones to
Yes.
operate under.
Under those, that bill, the language.
Page 3, he's saying that everything is listed on page 3 in that back section.
In the
16,
table of
16,
contents, the
Yeah.
table of contents that has the code section
Lists every
on the
offense.
left.
So if we wanted to pick and choose any additional offenses that we thought the public should be notified that someone should have to have the signed patient information on, we now have a full list of all possible offenses.
Right.
Good list to start with.
Yeah.
Yeah, at a glance.
And we chose to go with sexual
I
assault.
know, it's nicely organized, don't you think?
I don't see sections in our part on here that are violations.
I don't know, maybe just for this board, eh?
Good job.
Use of silicone. I mean, if I use that as a spray on my squeaky garage door, I'm getting into trouble.
Patient's garage.
Oh, patience. I can't use it on patience. Silicone spray.
He does it all, doctor, handyman,
Dishonest.
So all in all, if we get this approved, I think we'll have those 2 additional enforcement provisions. We'll have new forms for quarterly reporting, and we'll be in compliance with this uniform guideline. That's the goal.
Excellent. So we'll wait to hear from you for June.
Yes, yes.
Next on the agenda is the agenda items for the next meeting. What was the reason we couldn't accept the minutes?
There were not enough members in attendance.
Well,
We didn't have enough of the people who were there.
Oh, the people that were there. Got it.
Yeah.
Thank you so much.
So,
It's probably too early for next meeting.
future meeting dates, I've got October 19th, Sacramento. Anything after that date yet?
No, so I, placed January 2018, that's the next time you would have a meeting. And,
Am I still on the board January 18th?
So I replaced,
October 18th.
the Thursday dates in parentheses underneath, so I have the 4th, 11th, 18th, or 25th.
I'm sorry, what are the dates again?
So the
11th,
4th,
18th,
11th,
25th.
18th,
Which month?
and 25th
Every
of January.
January 2018. Oh, pick a Thursday.
I don't know what dates are available.
They've got them alive, January, I mean, as old as some of us are.
I would vote for not the 11th.
Not the 11th, so the
Not the
4th,
11th.
18th, or 25th.
I would vote for either the 4th or the 18th.
Oh, sure.
I have my own board schedule on here.
That's a short week, the 18th. It's a month, so
18th? 18th?
Yeah,
18th?
that's good.
That's on the 18th.
I will let you
Second
know.
one?
January
January.
18th, Thursday.
And that, yeah, in Sacramento?
Yes, always in Sacramento.
All right, I will.
We're in
Do
Sacramento.
we know where
We're
we're
okay
at?
for October 14th, is it?
19th.
19th.
October 9th, Thursday.
That was okay.
October, what was that October date?
October 19th in Sacramento as well.
Wait, isn't that AOA? Is that week? October 19th? AOA? Isn't the AOA in,
October,
yeah,
sometime there.
Airway or
I don't know for sure when. I'm not on a board, it's not as important for me as it is for you, Bill.
the only thing that's important to me is that you tell me where I'm supposed to be.
This what?
The only thing is you tell me where I'm supposed to be. I'll tell you where you're supposed to be.
I have OMED on the, starting around the 7th of October.
7, so it's early.
Yeah, 7 to 10 in Philly.
Okay. Just check.
Good meeting, people.
Are we adjourned? Do we need gavel or?
That gavel needs to be beaten hard.
Yeah.
We have enough time to make it to the airport.
You
Be
watch,
there an hour
you watch the
before our
nails,
local flight.
the nails will all pop out of it.
I have plans for the airport.
What is it?
Massage chairs.
Oh, you're gonna use that?
I'm going to one of those massage chairs.
Everyone, thank you for being here today. Dr. Lally, thank you for being such a good host. Happy birthday to Dr. Lally and to Angie and to everyone who's having a birthday.
Thank you.
Meeting adjourned.